Called to order the meeting for February 11th of the Children and Family Law Committee. And Representative Gregg, could you tell us in 2 or 3 sentences about the unfortunate thing that took place last week?
Sure. Well, as most of the committee knows at this point, but Representative Grossman's one of her twin boys, Oscar, actually had a very traumatic fall and is in critical condition down at Mass General. So,
thank you. And I have been asked if we could spend a brief minute in prayer for Oscar, and Vice Chair DeSimone, would you lead us in that, please?
Thank you, Mr. Chair. For those of you who do pray, please join with us. Dear God, please put your healing hands on Oscar and his family during their terrible time. Please give them strength and send them your love and our love, and know that our thoughts and prayers are with them as well. In Jesus' name I pray.
Amen.
Amen.
I open the hearing on House Bill 430, reducing the retention period for records of unfounded abuse and neglect reports by DHHS. Prime sponsor, Chairman James Spillane. Come on up.
Thank you, Mr. Chairman, members of the committee. I introduced this bill because I believe 10 years of retention for an unfounded report is excessive. If you read through this bill, you'll see that a screened out report is already kept for 4 years. If at some point that screened out report is deemed unfounded, it's kept for an additional 10 years from the date that the report was deemed unfounded. This does not deal with reports that were deemed founded or unfounded but with reasonable concern. Those are kept indefinitely. This is dealing only with unfounded reports. And having a report kept for 10 years, hanging over the heads of a family like the sword of Damocles, is an unreasonable mental anguish for that family, especially where if at any time during that 10 years another false report is made against the family and it's deemed unfounded again, the clock starts at 10 years for all previous reports that were deemed unfounded. So you could have a multiplying effect of report after report after report, 10 years starting all over again, and they won't go away. And by the time they do go away, that child is more than 50% chance is now a grown adult, and the family still has this hanging over their head. I can bring an example from several years ago when I was speaking with one of the members of the police training facility, and he'd been through a divorce and had custody of his children and 50%. And oddly enough, every time that there was some major event that they were going to be celebrating together, whether it be a trip to Disney World or whether it be the Sweet 16 birthday of the daughter or some other family gathering where he was taking the children somewhere, a few weeks before that was to happen, a report would be made with DCYF. And it was his belief that his ex-wife was behind it just to sort of spoil his time with the children. But each time that happened, of course, he had an unfounded report that would then start over again. And these don't go away quickly. I believe that 3 years is much more reasonable. 3 years gives the chance that it can go away before another report is falsely made against a family. believe that in as much as we as legislators are supposed to protect children from the abuse of strangers and bad parents, we also need to protect those families and those children from abuse by the state. And holding these kinds of things over the head of a family is mental abuse. It constitutes something that is always there, always hanging over them, and it's like a pall cast upon the family for the entire time until it goes away. This would not stop the clock restarting with another abuse case filed, but it would be for 3 years, not 10. And some of us may disagree whether 3 is better than 10. I think we can all hopefully agree that 10 is excessive. It's almost the entire lifespan of the child until they turn 18. I would inform the committee that I don't have a problem if we come up with a number in between 3 and 10, if that's something the committee wants to entertain. But I believe we have to make progress in trying to alleviate the burden of having this something that the state holds over the heads when it's an unfounded report, to have it there on an innocent family where it can be constantly referenced by people as, well, they've got a report on them sitting with DCYF. And again, I'll reiterate, a founded report is kept indefinitely, and one that's, as if you look at line 10, you'll see unfounded but with reasonable concern is also kept indefinitely. So if there's any concern and the report is unfounded but with reasonable concern, this doesn't apply. But if it's totally unfounded, there's no reason to keep that report hanging over the family for 10 years. And with that, I'll take any questions.
Your most recent comment goes to a question I had written down, that unfounded does not mean there's no problem, it's just there's not enough proof. It's the difference between being innocent and not guilty. But what you just said seemed to answer my question in line 10, an unfounded report, but there is reasonable concern, does keep the report on file. Is that
Indefinitely.
a correct assumption?
Indefinitely.
Okay, thank you. Representative Gregg.
Thank you. So just to clarify, you are aware that unfounded, and unfounded without anything else does not mean that there was nothing found. It also does not mean a false report, correct?
I do know that.
Okay, follow up. And are you also aware that, and maybe the people that are concerned about this is not like a sex offenders list or anything where people can look this up. It's incredibly hard to obtain and look to see if there is some kind of a report, even unfounded, on somebody. This is not something that there is a register of that anybody can see, an employer, family member, anything else. Are you aware of that?
I'm aware of that. However, it also is in the minds of the people in that family constantly until it goes away. It's as though they have to live with this ghost hanging over them until it's gone.
Representative Rice.
Thank you, Mr. Chairman. Thank you for taking my question. So would you not agree that by keeping these unfounded reports for the length of time we did could also be helpful if you are finding malicious reporting? You would have a record of all of these unfounded reports to help prove malicious reporting.
And I believe that could be done. Yes, thank you for your question. I believe that could be done in 3 years. I believe that any follow-up investigation that isn't completed in 3 years is probably not going to happen, but having it sit there for 10 is excessive.
Thank you for your testimony.
Thank you.
Chair recognizes Cassandra Sanchez and Attorney Lissa Macio from the Office of the Child Advocate. armed with handouts, as always. Yes.
Good morning, and thank you for allowing me to speak today. My name, for the record, is Cassandra Sanchez. I am the child advocate for the state of New Hampshire. As you will see, we are passing around some written testimony, and we are here today in opposition to House Bill 430. A number of reasons for this. One of them being it directly impacts the day-to-day work of the Office of the Child Advocate. In part of our work, we're looking at trends in the system, things that are working well, areas of improvement, and to be able to do so, having history of families, any touch points they've had with the agency, any actions by the agency in that time frame, allows us to see if the agency is growing in the right direction. In addition to that, we also see over time in many cases that we review, particularly in a lot of the critical incidents that we review, in which critical incidents are serious injuries to children. It can be a child fatality. It can also include parent fatalities. We review all of those in our office. And in doing so, an aspect of that is looking at all of the history of those families. Unless it is a newborn baby, we always see that there has been prior history at the point of going to a critical incident. If it's a firstborn child, oftentimes there may not be a history. But when we actually have gone back and looked at our CIRs, every single CIR has at least one call in to the agency before it's risen to the point that something serious has happened to that child or to that family unit. We also look at this as calls are coming in, and if we receive calls of concern to our office that somebody is worried about a child, the first thing that we do is go in directly into the DCYF case management system and see what touch points that family has had with the agency. In that, we have found times where it has taken multiple reports over lengthy periods of time to truly build the full picture of what that child is experiencing. So it may be, the first call from a school personnel saying the child's falling asleep in school, something seems off. Then it may be a call from a neighbor. We're hearing a lot of yelling in the home. Something is happening. And it actually takes the totality of all of those calls to build the full picture to say this is rising to the level of abuse or neglect. The first few calls very well could be screened out, but with those screen outs living in the system, the agency is able to look back and paint a picture of what is this child truly going through, and do we need to intervene to support this family and ensure the safety of that particular child. I also do want to thank Representative Rice for her comment, because we have seen it work in that aspect as well. We have seen where you can go back into records and see that there may be a history of malicious calls. Typically when we review those kinds of cases, it does have to do with a nasty divorce, and one parent may be calling repeatedly against the other parent. And by having that in the system, it is protective to that one parent who is doing right by their child, and it builds that history. So when the next call comes in, they can see those priors and say, this sounds like what's been called in time and time again, and we know it's not abuse or neglect. We know this is, clearly there's something playing out here in the dynamics in this family, and it's not appropriate for the agency to be involved. So it does work. We see it working both ways, but there is a lot that we can gain from that history, and having that historical information not only benefits the work that we do in trying to improve the overall system, but it does improve the day-to-day work of social workers within DCYF. And it is actually within their own policies that they are to review the history when they have a new call come in about a family. So they're really assessing the full picture of the family with any information that they've ever received on them. We also attached some data there for you on the final page. And so this is some data that we pulled, reports made to intake during January 2025. So those first few bullet points there are specific to this past month. And typically, because of the time frame, we don't have founded, unfounded, or incomplete results of an investigation 30 days later. So we pulled 2024 data to take a look at the founded, unfounded, and incomplete. And as you will see, what they have here, and these are for all calls received to the division in that time frame, 78% for whether it be founded, unfounded, or incomplete. So all calls in 2024 that came in, 78% had previous referrals at some point. And if you look at the data there, we also include percentage of reports with referrals that were more than 3 years since. And so we have all of that data there for you to look into a bit more, but wanted to share that it is very relevant that families do come back to the system.
And I just wanted to reiterate from a legal standpoint, Representative Gregg's point, the central registry, which only contains founded reports, is itself incredibly difficult to access. Under New Hampshire law, very few entities even get access to that. It is certainly not public record. And in fact, people you may think would have access to central registry do not. The unfounded and screen notes, which live entirely within DCYF's internal database, is accessible to essentially no one outside of DCYF. The Office of Child Advocate has access specifically through our statute under a very strict confidentiality MOU, and those records are protected by 170G8A. They are not accessible by a 91A record request, and 170G8A is extremely narrowly tailored to only allow access to a very small group of folks, including parents who are the subject of those reports, but otherwise it is not as though these records are publicly accessible, public knowledge. So the confidentiality around these records, regardless of how long they're retained, are incredibly high.
Representative Rice.
Thank you, Mr. Chairman. Thank you for taking my question. Do you happen to know what the average is for other states? Did we just put this in like in 2017 or something, right? Because that was best practices for other states.
Yes, that is accurate. I don't have the average for other states, but I can say for neighboring states that we end up working with on a regular basis, they do maintain their records for quite some time. You know, if we have a family that's come here from another state, the state of New Hampshire will request those records, and they can get a very lengthy time frame of records from those states as well. And so some of them have a lifetime where they keep them forever for the history of their agency, and others do have the longer time frame that we strove here in New Hampshire to raise. And it was about 2017. Yes, that's correct. Thank you.
Representative Raymond.
Thank you, Mr. Chairman, and thank you. Would you believe that New York keeps theirs for 10 years past the youngest child in the family's 18th birthday, and Massachusetts keeps them indefinitely?
Yes, I can absolutely say from my work in Massachusetts, they do keep them indefinitely there. Yes. And yes, that time frame for New York would be accurate as well. Yes, thank you.
Representative Nelson.
Thank you, Mr. Chairman. Thank you for taking my question. Would you agree that there are times in the case of a family with multiple children that the oldest child might have, there might be reports about the oldest child that might be unfounded, but with younger children, subsequent reports might show a more, I'm struggling to find the word, but more intensity of abuse that would rise to the occasion of having some action taken, and then when you look back, you might need to provide help and services for the older child as well?
Yes, absolutely. So there are many cases that we review in our office where an older child may even be freed for adoption and adopted out of the system because of severity of parenting at that time. And then later down the line, parents have other children. And if they do become re-involved, it is often looking for their trends in behavior, because what that tells us, those calls are telling us the behavior of that parent and their parenting style. And there are plenty of times where a child could be adopted out and the family could really learn from that and take services and grow and have an opportunity to parent successfully in the future. It is not an automatic because you had a termination of your rights on another child that the system is following you or is tracking if you're going to have other children. That does not happen. But there are other times where we see then those same behaviors that had happened in a case that could have been 10 plus years ago. Those behaviors are resurfacing with a new child born. And so that tells us that that parent hasn't had an opportunity to learn and grow their behavior in a more positive to create more positive parenting in the future. And that history of what happened with that older child is very important to understand what may play out with that new child and to be able to prevent something serious from happening and allow intervention earlier on by the agency.
Any other questions for our friends from OCA? No? Seeing none, thank you so much.
Thank you.
Chair recognizes Attorney Susan Larrabee from DCYF, who has information.
Good morning, Susan Larrabee, General Counsel for DCYF, and I'm going to have in my brain the brevity and concise and clear recommendation that you mentioned before. And listening to the OCA as well as listening to everyone's questions here, I really do not have much to add, except for I think as written there may be some inconsistencies of now with the retention, because as it's written now, the retention of a screen out, and again, just to define, a screen out is when a case is called into central intake and it does not meet a definition of abuse and neglect. So it is never even referred in for an assessment, is what's called screened out. And the way the bill is written, that remains untouched. So that would be retained for 4 years. However, an unfounded report would be now retained for 3 years. So an unfounded report in which it was screened in for an assessment, there was enough evidence at that point to screen it in. It did meet the definition, taken at face, meet the definitions for abuse and neglect, would be kept for a shorter period of time than a screened out case. And Representative Rice, you are correct, as well as Representative Nelson. There were many changes that have been made to the retention statute throughout many years of working on this, as well as one of the latest changes in 2017 also added another component of how an unfounded report could be used. Under the definition section, the evidence section of 169C12, the evidence section, it says that in any hearing under this chapter, the court shall not be bound by the technical rules of evidence and may admit evidence which it considers relevant and material. And then added in 2017, evidence of prior unfounded or unfounded reports of abuse and neglect shall be admissible in proceedings under this chapter in order to establish a relevant pattern or course of conduct. So we just want to be clear that unfounded is used in many different areas of the 169C, including 169C12, as I just mentioned, as well as 169C34, which lays out the different duties of the Department of Health and Human Services, DCYF in particular, when we are investigating and assessing cases of abuse and neglect. Specifically, Section B, which states, determine whether any person in the same family or household was named in a prior report of abuse or neglect, and if there are 2 or more prior unfounded or unfounded but with reasonable concern reports involving any family or household member, conduct an administrative review of all identified reports. Because as many of you mentioned on this panel, it is essential to make sure internally that we have not missed something, that is there a reason why there has been 2 unfounded reports on this family? And this statute requires us to do that. I'm happy to take any other questions.
Do you find it very difficult at DCYF to have a whole group of people very angry at you because you didn't take a child from a bad home, and another group equally angry that you did? And is that difficult?
Of course it's difficult, but of course we're here to follow the law and first and foremost make sure every child that we are touching upon is safe, and evaluate that safety and that risk and make sure, again, at the end of the day, we have not missed something inside that family.
Representative, sorry.
Thank you, Mr. Chairman, and thank you for answering my question. I am very new to child and family. This is my first year. But I did notice in the bill, it refers to a report that is unfounded but with reasonable concern. I'm wondering how many cases, if you have any statistics on how many cases are labeled as unfounded but with reasonable concern.
I do not have that data in front of me. I know we do track that data, and I could provide that for you. And I do believe that category, unfounded with reasonable concerns, was one of the latest changes that have been made to the statute. Okay. And basically what that means is that there is still insufficient evidence to sustain a preponderance of the evidence finding. However, there's reasonable concerns. There's probable cause. So it's at that very beginning stage.
Representative Cousin for the follow-up.
Do parents know the difference between an unfounded and a unfounded with reasonable concern? And I only ask that because I've never heard a parent say, well, it was unfounded with reasonable concern. It's always, they drop it at unfounded.
Yes, when the case is actually closed, they are given not just verbal, they're given verbal conversations with their caseworker, the assessment worker. They're also giving a formal letter, which identifies that that category has been made, lets them know that they have not been added to the central registry, that there's still no finding against them. However, defines what that concern is. What is that reasonable concern?
Any further questions? Thank you, Counselor.
Thank you.
Appreciate. And this concludes the hearing on House Bill 430. We will not be execing this until early March. So therefore, if people wish to amend it, tweak it, do whatever with it, look up some things, you've got a couple weeks. I open the hearing on House Bill 187 relative to restraining orders sought by a parent on behalf of a minor child. Representative Belcher, prime sponsor, welcome.
Good morning, Mr. Chairman, members of the committee. Happy to be with you this morning to introduce this bill that I hope will represent just a bit of housekeeping and a simple fix to a problem that has come up. So, for the record, Representative Mike Belcher, Carroll District 4, Wakefield. First, as you members of this committee, I'm sure, are very well aware, children are in a bit of a unique position because many of their rights and privileges as citizens are held in trust by their parents or guardians for them until they reach the age of majority. This acknowledges the basic fact that children are not independent. Rather, children are quite dependent. Unfortunately, it appears that we have crafted law, I believe probably in error as the result of the evolution of laws over time, that deprives children of certain legal remedies that are otherwise available to adults. I believe this circumstance, as it presently exists, is actually in violation of the United States Constitution, Amendment 14, Clause for Equal Protection. We're simply not allowed to craft law that treats people differently under the same circumstances. Presently, there are a variety of options, legal options, for adults to seek restraining orders that extend past the borders of their own household to other members of society. It does appear that we lack the enabling legislation that allows children to exercise that same privilege of law through their parents by bringing restraining orders on their behalf. Now, to address a little bit of a different issue, perhaps there is some skepticism, I don't know about this committee, but I have a little bit of skepticism myself, if I'm honest, about some of the due process provisions that exist in restraining orders generally. However, let me be clear that any consternation about that should not be a reason to oppose this legislation, because that's not the principle at play here. The principle at play here is that something available to adults generally should not be prohibited from children under law, a legal remedy. Now, there are some specific circumstances that led to me bringing this bill. A constituent of mine brought forward. I'm not going to go into detail on that. I'm sure some other people will speak to the rather horrific circumstances that this unfortunate error has led to in New Hampshire law. But the bottom line is the principle here at play is impartiality and equal protection. And we should not make any remedy available to an adult that isn't also available for a child with an adult, their guardian, acting on their behalf. And with that, I'm happy to take questions.
Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question. My question is about where this bill is aimed to go in statute, because it is being put into RSA 169C, which is the child abuse and neglect statute. And the entire rest of that statute is only people who are legally responsible for the care of the child who can be charged with abuse and neglect. Whereas my understanding of this particular bill, it's to be aimed at somebody who is not a member of that child's household, who has no legal authority and thus would not otherwise be covered by this statute. So my question is, why would the bill not focus on a civil restraining order, which would cover like an adult to an adult or any other person? Why not make a carve out under the civil restraining order protection that allows an adult to seek a civil restraining order for a child?
Thank you for the question. So, frankly, our laws, when it comes to restraining orders generally, exist as a bit of a patchwork. It is, frankly, beyond me and my capability and expertise to try to recraft the whole of restraining order law to no longer be a patchwork. I'm trying to work within the existing framework, and it is this law that enables parents to bring this civil complaint for a restraining order on behalf of their child. So it was just a simple matter of this is where it already was. This is where the error, I believe, exists in language that only extends it to a minor's family or household. So this was the logical place to work for the time being, at least, until such a time comes that somebody far more expert than I am can sort out the broader patchwork of issues that might exist in law.
Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. And you and I have spoken, and we have both spoken to the same family. And thank you for so eloquently presenting the bill and the problem. Would you agree that right now, without this becoming law, there are children in New Hampshire who are in danger from people who they should be kept away from?
Yes, and thank you for the question. And as I said, without getting too deeply into the broader questions about restraining orders in general, we have a system in place that allows adults to seek restraining orders for a variety of reasons, including members outside their own household. And we as a body have affirmed those laws, meaning that we as a body seem to think that there are adults in danger who should be protected. But yes, unfortunately, due to some errors that happened as the laws evolved, children were left out of this and are therefore continuing to be in the kind of danger that we've protected adults from, and we should therefore extend that protection to children.
Any other questions of the representative? Seeing none, thank you for your testimony.
Thank you.
And the chair recognizes, I think it's Alonda Peterson.
Can you hear me now? My name is Alonda Peterson. I actually created Jade's Law in 2019. And sorry, it's very emotional for me. I was contacted by Bikers Against Child Abuse that they were helping another family, and was made aware that the wording in the law only states for family. And I just wanted to come down here today to say that that was never my intention. When I spoke about it before in testimony, I said soccer coaches, pastors, it didn't matter who the person was. I believe that all the children should have the same rights and protections as everybody else. I am currently using Jade's Law because our predator was family. And I'm glad we made it. I'm happy that another family has the opportunity to speak on it and hopefully change the wording. I just want to help all the families and all the kids and help them feel protected and safe.
Would you be open to taking any questions?
Sure.
Any questions? Representative Rice.
Thank you, Mr. Chairman. It's not really a question, but I do remember you from when this bill came through and the Bikers Against Child Abuse. And so thank you for even bringing this to our attention in the first place. And let's see if we can expand on it.
You're welcome. Thank you. It's actually another mom that brought this wording today that she's going to speak. But I also wanted to say that I had written a book on Kindle and Amazon about our whole case. If you want to learn more about what we went through as a family and the fact that my child had autism and spoke in her own representation in court. And we talk about the bikers. And it's a really good book to educate yourselves. What's that?
Representative Nelson.
What's the title of
Yes,
that?
thank you.
My name means ready for battle, because that's what Alonda actually means.
It's okay.
Thank you, Mr. Chairman, for the question. Thank you, Mr. Chairman. Thank you for taking my question. I'm sorry about that.
Thank you. And anyone else? Seeing
Anybody
none.
else?
Thank you. And committee, I forgot. We're supposed to have that sign changed on the witness table for every new bill. And Representative Malone, you are not only very skilled, but you're nearest.
You have to take out the other one, yeah?
I know. You know, that's a hard thing to do when there's about 40 people watching you. Well done. Well done.
Awesome.
Yay. Chair recognizes Tracy Searles.
Is this on? Yes. Okay.
It is.
Good morning. My name is Tracy Searles, and I'm here today in hopes of resolving a serious issue that my family has run into. This past summer, I discovered that one of my children was a victim of sexual abuse at the hands of their best friend's father. When the state police got involved in the case, they instructed me to go to the courthouse and file for a restraining order on behalf of my child. I did what I was instructed to do. Sadly, the judge had to deny the protection orders that I requested on behalf of my child. The reason my request was denied is because the Child Protection Act, RSA 169C7A, currently states that a parent or guardian may file a petition for protection order on behalf of a minor alleging abuse of the minor by a member of the minor's family or household. My child was sexually abused by an individual who is not a family member and not a member of our household. I was shocked when I was informed that by the clerk that my only option was to get the restraining orders to go home, get my child, bring them in, and have them file for their own restraining order. The way the law currently stands, a minor must file for a restraining order for themselves, no matter their age or intellectual abilities. I believe this is an oversight in the law. The age of majority in New Hampshire is 18 years old. Anyone under 18 is considered a minor. A minor, in definition, is anyone who is under the age of full legal responsibility or a person who is not yet old enough to have the rights of an adult. A young child cannot understand the full ramifications of a restraining order, let alone understand how to file one. Honestly, I myself needed assistance from starting point to fill out the petition for the protection order because it was so confusing. How is it that this law requires minor children to file legal documentation on their own when the definition of minor clearly states under the age of full legal responsibility and not old enough to have the rights of an adult? I am legally responsible for my children's safety, education, shelter, food, clothing. If I were to ignore any of those responsibilities, I would be at risk of losing my children for neglect or abuse. How is it possible that I am responsible for my children's safety, yet there's a law that specifically is precluding me from being able to protect my child? The abuse that my child suffered at the hands of someone who was outside of my household and not a family member holds no less holds no less significance. I should be offered the same rights of protection over my children as those stated in Child Protection Act RSA 169C7A. Please help me in fixing this oversight. Thank you for your time.
Would you take questions if there's any?
I can try.
Well,
I'm completely out of my element, but I'm willing to do whatever it takes.
well, I want to confess to you, we are too sometimes. So anyway, any questions? Seeing none, thank you so much
Thank
for
you.
your story. It's very
Thank you so much.
compelling. Chair recognizes Joseph B.R.O. Give me the last part of your last name, please. Brown.
Oh, come on.
Yeah, that one was tough.
Thank you. I'll be brief. I believe, as has been said, sorry. As has been said, this, New Hampshire has a mishmash of how the restraining orders work. And I'm pretty sure when Jade's Law was put in place initially, this was done with model legislation from other jurisdictions. And as often is the case when that happens, things don't quite mesh with our laws and it ends up with an unintended result. And I don't believe the legislature ever intended to exclude a whole class of potential abusers from the option to get a restraining order. So I believe this is a very simple solution to fix that. And yes, as said, it ends up in a weird act, but in a weird portion in the RSAs, but it's the way that the RSAs are currently written, and it's really the only way to do it without completely revamping that. Currently, a parent could get a civil restraining order through the Superior Court system,
Right.
and solve this at great expense, rather than going to the Circuit Court system. So this puts it in the same system that is currently used for restraining orders, rather than having to go for a general restraining order at great expense, which would limit the option to only a few members of society who can afford to hire a legal team to obtain a restraining order to protect their child. This is the much simpler solution to that. I don't think I have much to add. I think it's a pretty simple solution. It solves the problem without undue effort.
Mr. Brown, would you take questions?
Absolutely.
Any questions for Mr. Brown? Seeing none, thank you.
Thank you.
That's the sum of the pink cards I have, unless, whose turn is it to clog the works up over here? Is it your turn?
It is my turn.
Are you clogging up a pink card?
I'm not. I just wanted to make a quick statement on the bill.
Sure.
Mr. Chairman, committee members, and audience members, I am noticing two gentlemen in the audience who I believe have worked wonders on behalf of children who have been intimidated, hurt, and abused by people. I personally was here when some of you spoke before, and I just want to thank you for protecting our state's children.
Thank you. Thank you. Oh, come on. Go ahead.
That's nice.
Seeing no further cards, I close the hearing on House Bill 187. And with the approval of the ranking member, I open an executive session on 187 so we can vote on this right now and send it on its way. Now, whoever moves OTP gets to write the. Would you like to do this?
I would if that's okay.
You would like to do this?
Yes.
All right. In full disclosure, I bought Girl Scout cookies from somebody else yesterday. I did.
That is okay. My girls have
Sorry.
aged out already, so you're good. They have hit middle school age and they have decided not to continue, which is okay with me as long as you support the community as a whole for Girl Scouts. That's all.
I'm a sucker for a sob story. You know that.
You know, there are a lot of girls out there who have benefited from Girl Scouts, and I am glad to see that support in any way possible.
Representative, would you think it appropriate that the people who are listening to our dialogue might feel compelled to buy some cookies from their Girl Scouts that they know?
Hopefully, yes, and hopefully encourage those to join as well, too.
Representative Levesque for a motion.
I move ought to pass.
Okay, a Republican second, because we do this. Representative Rice. We don't get thirds. Any discussion? Representative Love.
Thank you, Mr. Chair. Thanks for taking my comments here. My only problem is the effective date. I think it should read immediately after signing.
That would take an amendment? Yeah, let's get it across the way. Yeah. But thank you. Any other comments, Representative Raymond?
Thank you, Mr. Chairman. I think that there is clearly a gap in the law that was unintended. That is, when I heard about this case, you could have knocked me over with a feather. I was flabbergasted that you couldn't get a restraining order for your child. Having said that, I don't think that the child protection statute is the place to do it, because child protection statute is designed for people who have a caregiving responsibility so that after a finding, they can receive rehabilitative services and reestablish a relationship with that child, with the exception of sexual abuse. So I just don't think it's the right place for it. I'm going to vote for it because I think we need to gap it, but I would really feel more comfortable if there was a bill, or if this bill were amended when it goes along the other side, to put the change in language under the other restraining order statutes, so that in those circumstances where it is a coach or a neighbor down the road or whomever, the parent could file for the minor, instead of in 173B where it says now a minor can file for themselves. Because I feel like that would more address the circumstances that we're talking about in the way that the relief is being sought.
If this bill passes all the way through and is signed into law, we can bring back something on this subject next year. The prohibition is only if it's to the negative, and I really don't anticipate that. So I bet you could find somebody who would do just that, to not make new law, but put them where they belong. Okay? Anybody else? Motion before us is OTP ought to pass, moved by Representative Levesque and seconded by Representative Rice. House Bill 187, would one of my clerks call the roll?
Chairman Pearson,
Yes.
Representative DeSimone,
Yes.
Representative Rice,
Yes.
Representative McMahon,
Yeah.
Representative Nelson,
Yes.
Representative Seidel,
Yes.
Representative Love, Representative Corzine, yes. Representative Markel is not here. Representative Petrino,
Yes.
Representative Levesque,
Yes.
Representative Gregg,
Yes.
Representative Raymond, Representative Georges,
Yes.
and Representative Maloney.
Yes.
14-0.
It passes 14-0. Representative, is that an Irish Malone or an Italian Maloney? I knew that, but that's just... This concludes the exec session on House Bill 187, and we have 10 minutes before we take up the next bill. I don't think it can be, because it's got money on it. Thank you.
unsolicited. Thank you.
Thanks for doing what you're doing.
Representative Litchfield, please present your bill.
Thank you, Mr. Chair. I would like to please ask permission to bring Melissa Blasek up with me when I introduce the bill. Would
Sure.
that be okay?
You may
Thank you.
do so. She gets legislative alumna points.
The Honorable Melissa Blasek.
Indeed so.
Excuse me. I'm sorry about that. So I'm here to introduce House Bill 560. I am Representative Melissa Litchfield, representing the towns of Brentwood, Danville, and Fremont. This bill is not new to the state legislature. It has been brought up 2 times prior, actually. And the reason why I've brought up Melissa is because she's got a whole lot of history on this. I've served here in the State House. This is my second term, non-consecutive. And when I was not in, I was actually getting calls from parents that were very concerned about this. They were unable to access their children's medical records electronically once they hit the age of 13. They were told that the child had to set up their own email. They couldn't even set up appointments for their children. So it's morphed into to quite a lot. I've talked to quite a lot of people. Not only is the feeling that they should have access simply because the parents are the caregivers who knows best how to take care of their children, but also you have the medical bills that are involved as well. And I'm
Anyone named Melissa at the table may speak.
And I'm going to say I hate to say this. I always just keep it real, but I'm type A and I have a dog that just died at home and a sick kid. So here I am. And this is why she's here to be my quarterback today. So thank you.
Thank you, Mr. Chair. So I'm Melissa Blasek. I'm here representing Rebuild NH. Yes, as somebody who does advocate for parental rights, this is probably the most ubiquitous complaint I get from parents. Typically when they push back at, let's say, a doctor's office about this, they're always told it's required by law. So I think that they often think that in state law, there's something that says that a child loses access to a portal system at age 12, which is not true. But it is true that the laws have made it tricky for portal systems. Now, to be clear, all parents have rights to their child's physical paper medical record. And any parent who goes and requests their child's physical paper medical record will receive it. But they will receive it hand redacted for certain items. Okay? So federal law, Title 10, I believe, requires that children over the age of 12 have access to birth control treatments and addiction services without parental consent. So those would be things that would need to be redacted from medical records. And state law kind of redundantly requires access to addiction services and also STD testing and treatment. So those would also be things that needed to be redacted. When we put this bill in, I believe it was actually in 2023, and then we retained it to 2024. And then ultimately it was ITL'd because there was word coming down from the federal government that they were going to be handling this, and that never happened. So we're back. That's why this bill is in again. The issues with the portal system supposedly is that it doesn't redact in the same way that a paper document can be redacted. And so I think what's sort of happened is that medical providers have just felt like this is the simplest solution, is to just cut off access. But I mean, I don't know about your 12-year-old, but most 12-year-olds are really not capable. You can see I passed around a couple examples of policies from different doctors' offices. Some even specify that the child cannot use the parent's email address. So now your child has to have their own email address. Now, of course, listen,
most parents are going to set up an email address for their child that they have full access to, you would think, to do it that way. But this is just something that parents come to me all the time, and they're just outraged that they even have to jump through these hoops to be able to have full parental access to their child's medical records. Most people are not seeing paper. We all have the portals. That's how they keep track of things. So that is the purpose of this bill. That's sort of the history of this bill and why we are back today. I'll take any questions.
Thank you very much. As a preface, a brief preface to my question, I am part-time medical center CEO, and one of our providers is my wife, who's a family practice physician, and very often we discover that HIPAA, those sacred 5 letters, are invoked when HIPAA doesn't say what it's being invoked to.
Yeah.
It is a brush off in some cases. And therefore, would you believe that sometimes people already have more rights, but maybe we better put more into statute?
I would absolutely believe that.
Boy,
Mr.
that was
Chair.
a push question. Wow. Okay, Representative Raymond.
Thank you, Mr. Chairman. I have 2 things. One, I did not get your handout. I don't know where it
I just
went.
have one copy of some policies floating around that I have highlighted out, the children's policies. And then there's another handout that Representative Litchfield put out of the things that are sort of required in different statutes. There are copies of that.
Okay, so if maybe it could be emailed to the committee, I would love to see it.
There are copies.
No, I have that one. I don't have the other one.
Oh, the other one, the copies of the policies. Yeah, I have one copy of several policies floating around.
Representative Malone, since you are caring for the sign, it is not necessary for you to take on other difficulties, but thank you so much.
Thank you,
Yes,
Mr. Chairman.
Representative
wait,
Gregg.
Can I ask my question, though?
You may ask your question.
Thank you, Mr.
now.
Chairman.
I did see your hand.
Okay, thank you. My question is regarding line 19. Line 19 of your bill says, when a healthcare provider has determined by, and I'm going to use air quotes here, clear and convincing evidence based upon articulated facts, blah, blah, et cetera, then they can withhold the record.
Yeah.
My question is, where did that language come from? Because RSA 169C and every child protection law in every state of the country says that the duty of the practitioner is if they have reasonable cause to suspect. And every state in the country says for a finding of abuse and neglect, so for a court to determine a parent is abusive, it's a preponderance of the evidence. So where did this clear and convincing random level come from? And
Thank you for the question. I did not write this. This is a word for word the bill that was put in before. I personally object to this particular part, and I would like that section to be stricken. If I'm just, that would be my personal preference. I think that if a medical professional does have any type of thought that the child is possibly being abused or neglected, they are mandatory reporters, and that's how this happens. They are not judges and juries to be able to remove people's parental rights.
So there is an amendment in the works, but I just wanted to let you know the reason why the bill is worded the way that it is because they've tried to put this bill through 2 times prior. And there were concerns about if they didn't have this language, was the bill going to make it past the finish line? It's just as simple as that. But you're 100% absolutely right. It is not necessary, and there is an amendment out there.
thank you, because that's what killed it the last 2 times it was here. It's that phrase.
Representative Gregg.
Thank you, Mr. Chairman, and thank you for being here and presenting the bill and taking my question. So are there cases where parents are not able, so you're talking about the online, like the chart and stuff. I have a daughter that just turned 18. It wasn't until she turned 18 that she had to sign like a release or whatever if she wanted me to be able to continue to do it. That's when my email got shut down. Same with my son, who's now 21. It wasn't until he turned 18 that I was no longer able to access it with what I had before. So is that actually happening?
Thank you for the question. Yeah, I mean, when I was researching, I couldn't find a major practice that did not have a policy that you lost portal access at 12. I've stopped printing them off because they were all the same. And so, yeah, no, I haven't, that's interesting that you say that, because I haven't found that to be the case. I mean, my daughter is at a very small practice that's not associated with any major hospital, and that's their policy as well. So, yeah.
Follow up or
Follow-up.
second question?
It's
Either
a
one.
second question. So it's a would you believe, I suppose. So I make no secret that I'm a survivor of domestic violence, and as well as my children are. Would you believe that one of the first things that my late husband did when he was taken out of the home was to try to access their medical records before we had findings, before we had protection orders or anything else, to see if they were talking about something that he'd done?
Sure, I would believe that. I believe that's why Section B is in here.
But I would like to point out that this bill is specifically directed toward electronic records. So in that case, unfortunately, if he were to go in person, he would have access to their records.
I read in line 8, physical medical records and electronic medical records.
Yes, it's both.
So it is both.
It is both, yes. But currently they would be, we just put it in there to keep it clean, but currently they can have access.
Okay,
Yeah,
good.
that's
Thank you.
federal law.
Do you want to follow up? Okay. Anybody else? Question? For the representative and the representative once removed? Thank you, Melissa.
Thank you. Thank you.
Anybody else named Melissa who wishes to testify? Seeing none, Representative Mary Murphy.
Thank you, Mr. Chairman, esteemed colleagues, members of the public. I am Mary Murphy, representing Hillsborough District 27, which is Deering and Francistown. I'm also the CEO of a healthcare startup, Cost Cures, which I co-founded with an emergency medicine physician. I'm here to testify in support of HB 560 relative to parental access to minor and child's medical records. I feel this bill is needed to ensure that minor children's health care is properly coordinated by providing essential access to minor children's medical records by parents, except in certain circumstances when it is not in the best interests of the child. The bill clearly spells out these exceptions, which I will not repeat for the sake of brevity. One of the problems the bill seeks to address is a situation in which a minor child receives medication or care without the knowledge of his or her parent and is then treated with contraindicated medication or a procedure that could lead or could result in a life-threatening reaction or even death. This bill would help avoid these situations. I view HB 560 as life-saving legislation and urge you to vote ought to pass. Thank you. Are there any questions?
Representative Murphy wonders if there's any questions. Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. That actually has been a concern of mine, also with the portal system. And further to what you were saying, would you say that also medications that are necessary for whatever health reason, when they are prescribed to a child, and the practice is to request refills via the portal and leaving that responsibility to the minor child, could that be harmful for the child if they are not responsible in obtaining refills on time?
I believe it could.
Any other questions for Representative Murphy? Seeing none, thank you.
I appreciate it. Thank you very much.
And the chair recognizes Representative McFarland. He says he's from Orange. I think he's from south of London. Just wait.
Thank you.
Scottish origins, not English. Morning, Mr. Chairman, honourable members. I'm Representative Donald McFarlane from Orange, and I thank you for the opportunity to speak in strong support of House Bill 560. This testimony is representing my views and the views and interests of my constituents in Grafton 18. My testimony is not made on behalf of any private employer, nor should it be construed to reflect the views of any of my employers. It's absurd and outrageous that parents who are legally and morally responsible for their children are unable to obtain electronic medical records or are being handed redacted electronic medical records when they are seeking essential information about their children's health. It's even more absurd and outrageous to learn, as we have done earlier in this testimony, that healthcare providers are requiring that their children, that these parents' children have their own dedicated email address separate from and potentially outside of the supervision of their parents. Parents are expected to consent to treatment, to pay medical bills, and to make critical healthcare decisions on behalf of their children, yet they are being denied full access to the very records that inform those decisions. This is not just bureaucratic nonsense, it is dangerous. How can a parent ensure proper follow-up care, understand a diagnosis, or even recognize potential medical errors when they are blocked from seeing key details in their child's medical history? The idea that parents are being treated as outsiders in their own children's health care is an insult to both parental rights and to common sense. House Bill 560 corrects this injustice and ensures that parents can fulfill their responsibilities without unnecessary and arbitrary barriers. I urge the committee to restore sanity and transparency by recommending this bill for passage. Thank you for your time and consideration, and I'm happy to take any questions.
Questions to the representative, Representative Gregg.
I'm just confused. Thank you, Mr. Chairman. Obviously, I'm really confused. And thank you for taking my question. I'm confused as to where having young adults right now that were just children, where is this happening? I've had to consent to everything that they've had done medically. I've had to sign off on that. I've been able to get every medical record without it being redacted. Like, where do you have specific, or is there somebody here maybe that you know that's going to testify where this has actually happened?
So I think you've already heard precisely that testimony, and in my understanding in talking with some of the other representatives, let alone constituents who are supporting this legislation, is that in circumstances that they have been seeking precisely these records, as you've heard, they have been denied them or they have been given redacted records. So if I am somehow misunderstanding your question, I apologize, but I think you've already heard the answers on that.
Representative Rice.
Thank you, Mr. Chairman. Would you believe that if it happens to one person, it's too many and this is just good legislation?
I most certainly would.
Any other questions? Seeing none, thank you, Representative.
Thank you.
Chair recognizes Ben Bradley from the New Hampshire Hospital Association.
Thank you, Mr. Chairman. Good morning. My name is Ben Bradley. I'm the Vice President of State Government Relations for the New Hampshire Hospital Association. I represent all 26 of the community hospitals in New Hampshire, as well as all specialty hospitals. I want to thank you for the opportunity to testify and maybe provide some clarity or insight. We do have concerns about HB 560, but I want to state that we completely agree with the general statement of purpose of the bill. The vast majority of parents absolutely are acting in their child's best interests, already do have access to their child's medical record in some fashion, and are responsible for providing and continuing coordinating medical care. However, the bill as written raises some questions for us. I'd like to outline those. It does appear to resemble previous legislation, as was mentioned, and we continue to believe that it's unnecessary, as HIPAA already covers when a minor's medical record can be released. Rather than layer on additional regulations that raise serious questions about complications, we recommend the committee vote an expedient to legislate as you have in the past. Of particular concern, and what was talked about previously, was on line 9, including the words, including records available via online patient portals. To define the medical record this way creates a technology standard that currently cannot be met by many providers in the state. The bill acknowledges in Section 2A that there are records protected under federal, state, and state laws that parents are not able to see without their child's consent, such as substance abuse treatment, sexually transmitted disease treatment, reproductive health services, and for emancipated minors. Technology limitations of many of the provider's patient portal systems are not capable of the nuanced parsing of the medical record to redact these protected services, and therefore we would provide a hard copy or some other access, some other means to the appropriate information under the medical record. Additionally, I want to point out under the protective orders clause in Section 2B, it does raise many questions about the implementation and puts healthcare providers in a position to interpret complex legal documents and postures of the court. For one, preliminary protective orders can be issued without advance notice to another party. So, for example, one party could ask for a protective order. It could be issued temporarily or preliminarily, and the other party wouldn't even know. While the subject of the protective order is entitled to a hearing to challenge the allegations, that can be days after the initial order. Is the initial order sufficient to trigger this law, or is it after a contested hearing? Protective orders also expire. So what happens if an order expires but nobody tells the healthcare provider, which may be a situation likely to occur? What about bail conditions that include no contact orders? Would that be included under this law? How would providers know when the case is resolved and therefore the order is no longer valid? What about sentencing orders and other things that would make it difficult for the provider to comply? There's typically no paperwork that affirmatively says a case is resolved and the bail conditions or probation conditions are lifted. So what would be sufficient documentation for providers to lift the denial of access? Taking the above into consideration, if the protective order is no longer valid, but nobody tells the healthcare provider and the hospital denies access to a parent, the hospital would be in violation of federal information blocking rules. The proposed language puts the healthcare provider and the hospital in an untenable position of having to essentially do a deep dive into court orders, protective orders, bail instructions, etc. And so they can only act on official information that has been presented to them at the time of the medical records request. Finally, in the last section, we believe this is also unnecessary, as is the case with respect to all personal representatives under HIPAA. A provider may choose not to treat a parent as a personal representative when the provider reasonably believes in his or her professional judgment that the child has been or may be subject to domestic violence, abuse, neglect, or that treating the parent as the child's personal representative could endanger the child. Given these concerns, we're not able to support HB 560, but I'm happy to work with anybody or try to answer any questions.
Representative DeSimone.
Thank you, Mr. Chairman, and thank you for taking my question. I'm a parent of 3, a grandparent of 4. I cannot imagine not being told by a pediatrician who I trusted with my children's care that there were issues with my child, that my child needed help. Can you tell me why this makes sense for a physician not to tell a parent that their child has a substance abuse problem where they could overdose and die at night, whether they have any other issues that need medical attention? Where does it make sense that it's okay not to tell the parent?
I think there are existing statute that outlines the limitations of that and the rights provided to minors at a certain age to protect that information. I can't speak to the policy reasoning, but I know that that is the case and has been for a long time.
Thank you very much.
Representative Rice.
Thank you, Mr. Chairman. Thank you for taking my question. So can you please tell me what doctors' offices do now if there is a protective order that's brought in? Is this something they can't comprehend? I don't understand why that would be difficult. Do they want, I mean, if that protective order runs out now, it's still going to run out. Who's telling them, and what is the policy?
No, I think they act on the information that is presented to them. I think this statute doesn't nail down the qualifications in a way that makes it clear, especially if, as I mentioned, the protective order goes away and nobody's told the provider. How are they to know that the parent now does have access? So I will just reiterate that they act on the information that's provided to them to their best of their ability and assume that the parent is acting in the best interest of the patient, of the minor child, unless there's some indication otherwise, their professional judgment or some information is presented to them. I think the bill as it's written just outlines some broad swath circumstances that just make it a little more difficult than simply their ability to take the information that they have and be able to make a determination as to whether the parent would appropriately have access.
She has a follow-up.
Follow up?
Thank you, Mr. Chairman. So I'm having trouble connecting this, because if a parent comes in with the protective order, yet say it's good for a year, it expires, but they don't come back and tell the physician, you're still having that same problem.
That's true.
Thank you.
True. This codifies that problem into state law.
Representative Petrino.
Thank you, Mr. Chairman. Thank you for taking my question.
Certainly.
If I'm hearing this correctly, I think a big concern is the portal, and that technology at the moment is not capable of redacting certain information that by law needs to be redacted.
That's true.
Parents still have access with a hard copy if requested. Is that correct?
Hard copy and electronically by means that are outside of the portal, in a way that a record could be sent to them electronically, but also redacted appropriately to be in compliance with the existing statute.
Thank you very much.
Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking
Certainly.
my question. This idea, this problem of technology not catching up to the desires of many parents in the state has come up several times in the past. Are you aware of any fixes to the current software that would address this issue?
There may be developments in the future. I'm not aware of those, but at this point, all I can testify to is the technology limitations that aren't able to parse that out on the portal itself.
Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question. If this bill were to pass with the language changes to align the burden of proof to what everything else is, what would the hospital system do for their portal? Would they simply say portals aren't available for teenagers anymore? Or would they be like invest millions in developing the technology?
I think it's a good question. In order to be in compliance with the law, if the portal hasn't kept up or become capable of parsing out the protected information, then I would assume, which is a risky thing to do, I would assume that it would be difficult to provide access to the portal altogether. But as I said, I think providers do make every effort when a medical record request is made to provide the appropriate access. It may not be through the patient portal, which is for the individual's medical, use.
Thank you.
Seeing no further questions, thank you so much, Mr. Bradley.
Thank you, Mr. Chair.
And most everybody else on a pink card has asked to speak for 3 minutes. And so given the time, we will put the 3-minute rule in. If numbers of these people can do it in 3, the rest of you can too. And one of the best speeches I heard in this room was 47 seconds long. Needless to say, I didn't give it. The chair recognizes Cassandra Sanchez from the Office of Child Advocate with handouts, of course.
Good morning once again. For the record, Cassandra Sanchez, Child Advocate for the state of New Hampshire. And yes, we are passing out some written testimony. I am here before you in opposition of House Bill 560. Some of the points have been touched on already, particularly the clear and convincing evidence is very concerning to hold medical providers to that standard. So I won't drown on about that. But also another concern that I hold for this bill is that when we are talking about medical records, this is also inclusive not only of the safe space that children should have with their medical providers, but this is also inclusive of therapeutic records because those are considered medical records. It is really important for children to have a space where they can share about what is happening in their lives to adults that can act protectively for them. Doctor's offices, I can speak from personal experience. Whenever I bring my child to the doctor's office, they have a conversation right in front of my face asking, are you safe? What is happening in your home? Has there been any domestic violence? That is important conversations to really assess whether the child is safe in their home environment. And when they reach a certain age and have the privacy to do that with their medical professional, it may not rise to the level of abuse or neglect, but it may be something noteworthy that goes into their chart. And with parents having direct access, that could become a dangerous situation for a child. I also want to share an experience that we had in a case that we were overseeing for DCYF. You may already be aware, but I want to make sure it is very clear that parents who have their children removed from their care by the division maintain their rights, which means they still have access and they still are in decision-making roles of their children when it comes to medical and educational.
30 seconds.
And what that means is that they have direct access to their medical records. We had a parent that had a founded allegation against them for abuse of their child. And that very parent was using the access to the medical records through the online system to continue to manipulate that child, although that child was in the care of the division. The division can bring these things to court, in which they ultimately did, but it is not immediate. So in that interim, this parent was manipulating this child, was canceling out providers and removing releases so the child was not receiving appropriate care, was accessing medications and removing the child from medications without the appropriate tapering down from the medication that's required by the medical professional, to the point that the medical professionals themselves said they could no longer treat that child because the level of manipulation and control that was happening was so dangerous that they did not feel it was appropriate for them to provide care to that child. So this also happens to our children in care.
Questions for the advocate? You're going to have to turn your mic back on. Representative Raymond.
Thank you, Mr. Chairman, and thank you for coming to speak to us about this. I didn't realize until you said it that this would apply to therapeutic records. And so my question is about a Supreme Court case in Reberg, New Hampshire 658, 2005, which talks about how parents don't, it was a Supreme Court decision that said parents don't have the right to a child's confidential therapeutic records. Would this bill override that Supreme Court case?
It would.
Or be in conflict with?
It would be in conflict with that. And I do believe, my understanding, and if I misspeak, please somebody correct me, but my understanding is that once legislation is changed after that, the new legislation would trump that prior court decision.
Any other questions for the advocate? Seeing none, thank you.
Thank you.
The chair recognizes Kathy Stratton from the New Hampshire Medical Society. Did we get the handouts from the previous speaker? Did they go by me and I? Oh, you did your job.
I did my job.
You did? All right. Oh, yes, I did get it. I didn't do my job. Sorry.
Here we go. Mr. Chairman, here's your handout.
Thank you very much. Okay, that was on my clock. You may go. Got to turn the mic on.
It's on now. Excellent. Check my watch. Good morning. It's still morning. And I will preempt the question. I will submit my testimony electronically after this. My name is Kathy Stratton, and I'm the New Hampshire Medical Society CEO. And I'm here to speak in opposition of House Bill 560. I want to state clearly, first of all, that physicians value the role that parents play in the treatment team, the care, and the protection of minors. The society, however, has concerns that, as proposed, this legislation would interfere with the physician-patient relationship. Under HIPAA, parents already have access to the minors' medical records, and exceptions under the federal law address important safety needs of the minors, effectively balancing the needs of guardians with those of minors who need protection and additional confidentiality. Again, in the majority of cases, parents are valued in a valued part of the minor's healthcare team. When considering this bill, our physicians were concerned that under the bill, some vulnerable minors who could not be guaranteed a level of confidentiality would either avoid or delay medical or behavioral health care. Delays in physical health care often result in more complicated and more costly medical care, sometimes resulting in irreparable health issues as a result. I want to also highlight the impact that this bill could have on behavioral health care of minors. Confidentiality is paramount to treatment, and for treatment to be effective, the patient must be able to disclose behaviors, thoughts, and feelings without fear of judgment or punishment. Imagine how intimidating it would be to worry that what you said would be revealed to those who you would want not to disclose that information to. This committee is responsible for the laws that govern many of New Hampshire's most vulnerable populations. I believe that the additional barriers in this bill to New Hampshire's most vulnerable populations, I'm so sorry. I believe that the physicians in our communities are vital to protection of this population, and I urge you not to support measures that would effectively increase the barriers to physical and behavioral health care. Thank you for your time and consideration of my testimony.
Thank you. Do you take questions, Representative Nelson?
Thank you, Mr. Chairman, and thanks for taking my call. Not taking into consideration therapeutic or other things that we talked about that needed to be redacted, I'm a little bit confused because how would this become more dangerous when a parent can at any time ask for hard copies? So what would be the difference between obtaining information that is currently acceptable to obtain through hard copy versus that of online portal information?
I didn't address the hard copy. It was more, I was talking to the burden of proof, where a physician, a minor may not feel like they would have the confidentiality to come in to address certain physical or behavioral health care issues.
Representative Love.
Thank you, Mr. Chair, and thank you for taking my question. I guess this is a would you believe. Would you believe that many prescribed drugs lead to abuse of similar drugs? For instance, Adderall. My daughter was prescribed Adderall in the 7th or 8th grade, and by the time she was a sophomore in high school, her and all her friends that were prescribed it also were crushing them up and snorting them. She took us on a 7-year run smoking crack and ended up doing heroin. It was a run through hell. And don't you think that the parents should have had, I mean, my ex-wife thought it was okay. I wouldn't have approved. Don't you think I should have had a little bit of say in this? And I wasn't entitled to it. Could you comment on it?
I'm very touched by your story. And I worked for several years in the recovery field with actually medical professionals who are recovering from abuse. You know, I'm not involved in that patient relationship, so I'm not sure that I can speak to that right now. And again, we're not here to put barriers. We're here to protect our vulnerable populations, the children. And you know, again, I'm so sorry for that.
Follow-up question, Representative Love.
Wouldn't it be safe to say that 12 to 17-year-old children make bad decisions? You know, given the if they're given narcotics to for any reason whatsoever, don't you think that they make bad decisions and they should have both parents helping them?
I will leave that. I can't disagree. As a parent of 3 adult children who have made some questionable decisions, you know, I will say that, again, we're here to speak to those vulnerable populations, and I can't speak to the situation of why a physician in this particular situation wouldn't have disclosed it or what the particulars are. You know, we value the role of parents, and our physicians really want to engage with parents. We're speaking about maybe that small percentage of children who very much need that confidentiality.
Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question. Kind of along the lines of things that are already protected and redacted as per state law, like substance abuse and reproductive health choices. Would this bill prohibit practitioners in New Hampshire from following the state law that requires those things to be redacted?
I'm not an attorney. Okay. I think we would have to consult an attorney as to which would preempt and how this would play out. I can't speak to that.
Okay,
I'm sorry.
Representative Cozen.
Thank you, Mr. Chairman, and thank you for being here to answer our questions. I just want to ask you your opinion. Is it more important that we prioritize the patient-doctor relationship over the parent-child relationship?
Thank you for the question. You guys are hitting me hard today. These are very, very challenging questions, and I think I will tell you that the physicians that I spoke with in regards to this don't take these decisions lightly, and they think very carefully. I can't get into what the nuances of any given decision, or you know, I think that there are good questions that are coming out here, and as a parent, I wanted to be involved, and again, I will say I was always asked for my permission, and I was never denied access to my kids' records. And I can understand that in certain circumstances, you know, you as legislators might question that, but I think having the ability to act protectively is important. You know, we don't want to look back and say, oh gosh, that level of protection should have been afforded to that child because now there's been a devastating consequence. So I think we're coming at it conservatively from a patient and physician perspective.
Thank you for your testimony. If she's comfortable with it, could you answer that question where a lawyer was needed? Neither am I. Thank you. Representative Betty Gay. Representative, we are on the clock. Either sit down or please give your testimony. One or the other. Okay, the part of Representative Gay is being played by Representative Kofalt in tonight's performance. Okay, thank you.
Thank you, Mr. Chairman. And if you can tell me where to get a blank pink card, I will hand one in after my testimony.
Appreciate that.
Retrieve
No,
one from
I'm
another
making
room.
one.
Thank you, sir. So for the record, my name is Jim Kofalt. I represent Hillsborough District 32, representing the towns of Wilton, Temple, and New Ipswich. So I am quite familiar with this issue. We had this bill 2 years ago in Health and Human Services, and it seems that it is a recurring issue. I think at the time we had retained the bill and in the hopes that this would be addressed at a federal level, because there was at the time something called the information blocking rule under consideration by the Office of Civil Rights, which enforces HIPAA. I understand that there are challenges, there are some technical challenges with implementing something like this. Having said that, since we have not seen any action at the federal level to implement changes that would require parents to have adequate access to their children's medical records and portal access to set appointments, for example, I think it's important that we move this bill forward in order to effect some change. I spoke to a parent just 2 days ago who called me about this bill and said that she is actually being told that since her son has turned 12, she no longer has access, that neither of them has access to the portal. And she is now unable to make appointments. Even she can't just get her son's credentials and use them and go online and make an appointment. There is no access at all. And so that is creating a barrier. It's creating an inconvenience. I know that parents who want their children's medical records can get those pursuant to HIPAA, but there's an extensive process of redacting information from that and making sure that any protected information that may be safeguarded by federal law, state law, or both is redacted so that the privacy is not violated.
30 seconds.
I'll just wrap up. I think it's important for us to keep the pressure on and move toward a solution, and I think this bill helps to do that.
Thank you very much. Questions for the representative, Representative Petrino.
Thank you, Mr. Chairman, and thank you, Representative, for taking my question. You mentioned parents' inability to make appointments for their children. Are they still able to pick up a telephone and make a call to schedule an appointment?
Thank you for the question. So if the provider or facility is taking appointments by phone, yes. I was told by this particular parent that she is being directed to use a smartphone. She does not have a smartphone to make the appointment. So I am not familiar with the particular mechanism that they were asking her to use. It was not the patient portal. It was something else. And there's some frustration that this is causing her to jump through some additional hoops.
Thank you, Representative. Chair recognizes, I'm going to say Viking Hedberg. My Norwegian's a bit rusty. How did I do?
Quite well. Actually, Viking is not a real name in Sweden, but it was my grandfather's name.
You're Swedish. I
So
know the. I beg your pardon.
there's an issue across
I
the
know.
lines.
Yes, sir, I do.
And I appreciate the opportunity to come before you today. I'm a pediatrician who's been practicing in New Hampshire since 1997. I also did, after my 3-year pediatric residency, I also did a 3-year fellowship in adolescent medicine. And this issue about privacy is really challenging. And I'm testifying in opposition of this bill. And I hear your concerns very much about parental involvement, and there's no way I think clinicians are trying to decrease parental involvement. You know, I work very hard trying to keep parents involved in productive ways with their kids and building relationships. The challenge with this bill, well, there's two things. There's one, it's unnecessary because HIPAA is quite clear parents do have access. And the issue trying to be solved legislatively here is one of technology and organizational policy. I'm only representing myself, but I believe Dartmouth Hitchcock both parent and child has access to the portal, but it's able to be separated in Epic, their electronic system. I work for Concord Hospital, which has Cerner, which doesn't have that ability, so they just shut it down. It is incredibly frustrating. It's frustrating to me as a clinician, it's frustrating to parents, but it's not a legal issue, it's an issue of being able to solve the problem. The one thing that HIPAA has in it that this doesn't is it allows parents to deputize their children to have access. Now, no place is doing that, but there's no magic when you hit your 18th birthday, you develop maturity. I can tell you a lot of 19-year-old males whose frontal lobes I do not trust one bit. So it's a process of development, and I think there have to be thoughtful ways within our profession where we gradually hand control and ability over to the young people, and that's a healthy progress that happens in schools, happens in communities. This bill,
Half a minute, Doctor. Thank you.
this bill blocks that, and it's also unneeded because there is access. I'll leave one other thing is we get asked really bizarre questions in the office. I've been asked, if I masturbate, does my penis get longer? And if my parent was reading that, I think I would be pretty embarrassed. So I want to protect privacy. I want kids to be able to talk to me without fear that what they say is going to be put verbatim back to the parents. One other thing is Cerner is bought by Oracle. They are now going to be using AI to transcribe our visits. It's going to open up a whole other issue of what goes into those records and how we edit them.
Doctor, will you take questions?
I would be happy to take questions.
Questions. Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question. So my question is about the technology piece, because I was kind of baffled by some of the previous testimony, because my child is 16 and I was in his patient portal this weekend, reconciling his PT bill with his PT dates, being like, why are these not the same? We figured it out. So my question is there a cost issue with the various systems? Like, why is there such disparities between these technological systems between hospitals?
That's a very big question. And these systems are huge. They're incredibly expensive. They're incredibly expensive to implement, and they are not necessarily efficient nor designed to do what they actually have to do. Some are much better than others.
Thank you, Doctor.
Thank you.
You may be interested to know I absolutely despise portals and refuse to be on any of them.
Could I answer that question?
That wasn't a question. That was a parting shot, but sure.
Can I comment on that? As the son of my father who passed, I had to be on every one of his portals to make sure care was appropriate. And there were prescribed medicines that were contraindicated, including one that was prescribed by a cardiologist that increased his risk of death by 50%. And if I wasn't diligent, he would have been given things that were problematic. Now, it's hard because our health system's really complicated. It's really in silos. I wish it worked better.
I know.
But without that portal, he would have not been with us nearly the length of time that he was. And
Well, thank you.
for that, I was grateful for
Thank
the
you,
access.
Doctor, very much. What I learned from that is I'll make sure my children are. Chair recognizes Anne Marie Banfield for roughly 3 minutes.
Thank you. For the record, Anne Marie Banfield. I'm a parental rights advocate in New Hampshire, and I focus on education, but I felt compelled to come to this hearing. First of all, Bedford, years ago, I asked them to put their check registry online, and they just did it. And they redact everything that needs to be redacted. So I'm not sure how a school can do it, but a medical facility cannot. Insurance companies get our medical records, and now we're just basically saying no to parents, again, showing the difference. Also, there was a Supreme Court ruling, I think it was Timberlane, where they were asking for Timberlane schools were asking for electronic records, and they had to go to the Supreme Court, and the Supreme Court said, yes, you have to give electronic records if a parent asks for that, or somebody files it through a 91A. The term dangerous was brought up, and by the way, I do get a lot of comments from parents about this. I had no idea. My children are adults. I had no idea that this was even happening. But because I'm a parental rights advocate, I do hear from parents that they're not able to access this information. But we heard the term dangerous. It's going to be dangerous to provide this information to parents, although they can get it through electronic record. So if a child comes in and is talking about his penis enlarging, they would be able to get it through written record. So I'm not sure what that correlation was. But, you know, I go in, and I normally don't share personal information, but I go in every 3 months for phlebotomy. I've got a blood disorder, so my blood's thick. I don't know how to describe it in medical terms. So I go in every 3 months for phlebotomy, because if my hemoglobin level goes up too high and I have a stroke, that would cause more medical problems. So if my hemoglobin level is at a certain level, if I have a stroke, I should be able to survive it in a better way. So knowing that my blood has that disorder, if my daughter, who is now 30, had gone in to seek birth control at an early age, and I know that that information's redacted, you literally would have put her in life-endangering position. I can't take birth control. I couldn't take birth control because that's a ticket to stroke, and that's a ticket to blood clots, and that's a ticket to death. So yeah, there are there are medical problems that people have that if they're cut, if I would have been cut out of the scene, you would have put her life in danger. And my son was in the hospital for 2 weeks. Blood clots everywhere during COVID. He's lucky to be alive because he has it clearly. He clearly has it. So my point is, you talk about danger. You put my daughter on birth control without running this blood test, and I wouldn't have known I had this blood test because I went through a kidney transplant, I had to have this blood work done, and that's where they found it.
Thank you, Ms. Banfield. Any questions for the witness? Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. Would you believe you're not the only person who has encountered this issue? I myself took hormones for change of life, transition, let's say, and I ended up with a saddle pulmonary embolism, which is nearly fatal, and it's usually not discovered until autopsy. And it's vitally important that my daughter tells every physician, because it is an unknown reason why I have this issue, although my father and my grandmother have it as well. So would you believe that you are not the only person with this issue?
Oh, absolutely. I mean, you talk about a vulnerable population. I keep hearing the term vulnerable population. What about the vulnerable parents out there that are being cut out? What about those parents, and what about their children? We talk about vulnerable. We got to protect these vulnerable kids. Well, you're not protecting my daughter with this kind of redacted information.
Question, Representative Raymond.
Thank you, Mr. Chairman. And thank you. Would you believe that as a survivor of multiple strokes, I told my 13-year-old daughter about the risks about birth control so that as she transitions into adulthood, she can make responsible and intelligent choices and have confidential discussions with her doctor? Would you believe that parents have an obligation to parent their children and not leave out important information that would allow their child to survive?
Thank you for the question. I don't think that the disparaging kind of remarks that you just made in your facial expressions was necessary. But in addition to that, yes, I would tell my daughter. There's not always the correlation. I didn't have a stroke to share that information. thankfully, we caught it before that actually happened. And yes, she's aware now, but at the age of 16, this is when they were running the tests on me. This is when they were finding out this information about me, because I had my kidney transplant 14 years ago. She's 30 now. So in that time frame, would I've had the knowledge at that moment? Maybe not at that moment, but maybe at that moment, maybe I wouldn't have put it together. My point is, now that I do know, of course my daughter knows. My daughter's a nurse practitioner. She sees all the people coming in who've had COVID, who have had strokes, who have had blood clots, and who understand now that putting them on a birth control pill comes at risk.
Thank you for your testimony. Chair now recognizes Betty Gay, former state representative.
Since we're all probably getting hungry at this point, I really will be brief. Okay, Betty Gay from Salem. And 6 years ago, I was presenting, well, no, I didn't even get to present because they double booked me. I didn't get to present this bill, but this is the third time it's being presented. Okay, we handed out some tables that are include, among other things, the federal confidentiality rules. So we can't overcome them, but we can overcome the New Hampshire confidentiality rules that this bill is trying to address. Okay, so you have that, and at your leisure, you can choose which ones are meaningful to you. Excuse me. Unfortunately, they combined New Hampshire and federal, so you have to read it quite carefully to figure out. But most of it, and I wish my voice would stop shaking, but I'm trying to talk really fast. Okay, so for one thing, there's a difference between federal and New Hampshire, and we're trying to be respectful of the federal, but we want to get rid of the New Hampshire confidentiality rules that are being so harmful to families with teens. And a lot of the issues that are being discussed would apply to children younger than 13 too. So some of the arguments have holes in them. There are safeguards written into this bill. So under Roman numeral 2, B and C definitely give people in authority who have access to this information the right to prevent parents from accessing it if they think it's dangerous. We're also talking about the mass majority of children have parents who are responsible, and where the hindrances built that are in the system right now are hindering the majority of people rather than be protective of the few kids who really do have parents who somebody should be separating their authority from the child. So both B and C are really, really important and refute a lot of the arguments that are being presented against this bill. Yes, I've already said all ages of children, some of these arguments apply to. So this bill is not, doesn't really solve those issues for age.
20 seconds.
Clear and convincing evidence definitely can be amended, and it sounds like it's going to be. There is not only HIPAA, but FERPA, which I'm not familiar with, but the federal records cite it as a very important document about children's records. And if an older child needs to let their doctor know something they don't want their parents to hear, they've got a telephone. Also, you don't have to put every single thing in a record. These, what sounds funny, questions of a child asking their doctor, that doesn't have to be in the record.
Thank you, Representative
Thank you.
Emerita. And that you got a lot of words packed in there. I know you normally speak slowly. Any questions for the Honorable Betty Gay, Representative Gregg?
Thank you, Mr. Chairman, and thank you, Honorable Gay, for being here and taking my question. Because you've worked on this legislation numerous times, as you've said, and you've had it before, and we're assuming that the majority of the parents are good parents who have healthy relationships. What is it about this bill, or what is it about what's happening in the world that these good parents are not able to have conversations about the medical part of the kids' lives and be able to already see their records and stuff. I know that I can. I assume I'm an okay parent because I can do all that. So I'm just wondering what is stopping parents from having conversations with their kids?
I'm thinking about how difficult it is to get your child to get, say you have a perfect relationship with your child and they don't know what's protected. They don't know that that you can't find out if they ask for birth control pills because the federal prohibitions are on that. What if they're afraid to tell you? And also, can you imagine getting your child to give permission to every single provider that they hear and make sure that the communication doesn't break down? I really feel like since you haven't experienced it, you're having a hard time believing what's happening to most parents.
Follow up.
Would you believe I have experienced this because of my relationship with my late husband? And I do have continual conversations with my children so that they're not scared to talk to me.
Well, that's certainly the goal for all of us.
Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my call.
That's twice now, but that's good. That's
We're really
Sorry.
getting hungry here.
My question.
Don't always do that.
I don't know why I keep saying that. Would you believe that despite my warning my daughter about the need to discuss low estrogen or high progesterone birth control with their doctor starting when I thankfully did not pass away from a pulmonary embolism, and I kept repeating it to her that when at the age of 15 she went to obtain birth control, I had no knowledge from the doctor of what type of birth control she was on.
I do believe it. And the sad thing is that under federal law, you still wouldn't be able to know that unless your daughter told you. We can't change the federal law, but at least we can change the New Hampshire law.
Thank you.
Thank you.
Question?
Is there
do have a
anything? Sorry. Thank you for taking my call. Question.
Well, you're welcome, Representative Malone. Carry on.
Sorry. Is there anything preventing parents now, whether they have a good relationship or poor relationship with their teenage child, to still give the doctor that medical history that these drugs could be dangerous to my child in the future at 7 years old, 8 years old, 10 years old? So that information's already there, so the doctor could have that conversation with the child if the child's not listening.
I don't see anything in this bill that would prohibit the parent from giving information to the doctor. It's just the parent might not know who the child is even seeing until they get a bill.
Do we know if that's like follow up? That's what that's. I don't even know how to question this. Do we know how often is this like really happening? Because again, to me, I bring my kid to the doctor and I was there and we had the conversation about birth control for her period cramps. She's going to hate that this was publicized. But we had those conversations, and I just always remember those providers. So are these like one-off providers, like maybe just a sexual health provider versus their PHP, the person that their pediatrician that they've always seen? I haven't experienced it. I'm fortunate, and I know that.
Right, and we think that most people would not if these prohibitions were stopped. It's just that the prohibition is there. There's a lot of ignorance implied, and it's just not good parenting to be told your child has now turned 13, so you can pay the bills, but you really are not supposed to be involved.
Thank you.
Thank you. And the chair now recognizes Matthew Hood.
Thank you, Mr. Chairman, members of the committee. For the record, my name is Matthew Hood. I'm the Vice President of Government Relations at Dartmouth Health. I promise I will be quick. I wanted to start by saying how much value and emphasis the providers in the pediatrics and primary medicine place on the engagement of parents in their children's health. We strongly encourage that in a minor's care. And we also want to be mindful of those scenarios where that could either be problematic or is prohibited. That being said, what I was hoping to emphasize for the committee today is things that have already been said. So the differing standards between the federal law and the state law, at least as in the current version of the amendment, clear and convincing evidence, is something that we would like to work with the committee on remedying because we find compliance with two standards to be a somewhat challenging proposal. I think to the chair's, what I heard to be the chair's earlier comment about wanting to provide clarity with respect to what parents are enabled, as well as the parameters about when that's not, totally on board with helping to facilitate that process. And finally, I can't speak to the portal. My daughter turns 12 in May, so I will be able to speak to the portal situation fairly soon, I suppose. But happy to pursue any the answers to that question from the Dartmouth Health perspective, if that would be helpful.
My sense is that there's some good stuff in this bill, good intentions, and some work needs to be done. And it would be very helpful, because I don't have access immediately to it, to actually have the HIPAA regulations as they exist and not as people think they exist. And that's all over the map. And compare, contrast to the state rules. And if you want to be an advisor to somebody, I volunteer you to them, because this could be a good thing.
Thank you, Mr. Chairman, for the opportunity. I would be happy to do so, or delegate my colleague, Courtney Tanner, who's probably listening at the moment, to participate in that process as well.
Representative Rice.
Thank you, Mr. Chairman. Please see me after the meeting. Thank you.
And is your name pronounced Hood or Hood?
I always feel like I should write in parenthetical H-O-O-D. It's Hood. Thank you, Mr. Chair.
That would be helpful. Thank you. Any questions for Mr. Dr.?
Mr.
Okay.
Matthew, either one's good. Yeah.
That's fine. Now that we've got your name sorted out, there's no questions. Thank you for volunteering your help. And with this, I close the hearing on HB 560. Bon appetit.
Yeah, right. I'm not like, thank you.
I'd like to open the hearing on House Bill 661 FN, an act relative to the Department of Health and Human Services management of Social Security payments, supplemental security income payments, and veterans benefits for children in foster care. And the chair recognizes Representative Mary Jane Wallner, the prime sponsor.
Thank you, Chairman Pearson and members of the committee. I'm Mary Jane Wallner, and I'm a state representative from Concord, and my district is pretty much right across the street. You can almost see it from here. In September of 2023, NPR ran a story entitled, "Kids Get the Bill for Their Own Foster Care." And nationwide, 5 to 10% of children and youth in foster care qualify for Social Security disability or survivor's benefits. These are children who have had a parent that died, or a parent who is disabled, or a child who themselves has a disability. Across the nation, including New Hampshire, the states have retained these benefits when a child goes into foster care. But that is changing. Many states are moving to preserve the benefits for the foster child, making sure benefits are held securely for the child until they are no longer in care. Last year, I brought in House Bill 1598, which would have changed the New Hampshire practice of the state retaining the child's benefits to reimburse the state for the child's care. This committee overwhelmingly passed the legislation, and when it reached the Finance Committee, there were many questions from both legislators and state personnel on how the new policy would work. So House Bill 1598 from last year was amended to provide the Department of Health and Human Services with funding to hire a consultant to develop a report and a roadmap as to how New Hampshire can implement this new policy. In December of 2024, just a couple of months ago, the report entitled Child-Centered Benefits Management Assessment was completed and provides New Hampshire with the information and process needed to enact this policy. I have made copies of the findings from the findings pages of the report for each of you, and I've got one for all of you. And I'm leaving a copy of the full report with your committee and I'd be glad if any of you want your own copy of this, I would be glad to make a copy of it and get it to you. I would like to urge the committee to pass this legislation so it can go to the Finance Committee. The Finance Committee obviously worked on this bill last year and made a decision to put in a sizable amount of money to hire a national consultant to come in and help New Hampshire with what would need to happen in order for this policy to take place. So the bill really needs to be in finance so that finance can continue to explore this policy. So I believe the hurdle for this bill is a financial one, and it needs to go to the House Finance Committee, and I hope you will vote to move the bill along. There are many people here today who can provide testimony on the bill, including at least one young person this state policy has affected. You will hear that what a difference these benefits will make in the lives of children leaving foster care. I recently visited a homeless shelter in Manchester that is for youth ages 18 to 24. And the staff told us that about 40% of the young people in the shelter have been in the state child protection system, foster care, or in residential placement. Think of the difference it would make in the lives of young people if their benefits have been preserved so that when they enter adult life, they will have a chance of going to college, having a place to live, affording a car so they can get employment, being in state custody is hard enough for a child. Sorry about that. Without losing the benefits that provide them a safety net as they enter adulthood. So I hope that I can urge you to pass this on so that we can have a discussion in finance about the financial issues around this bill and the details to how we would put this in place.
Notwithstanding the motto, finance is where good bills go to die, it would seem that finance has done a wonderful job up front. So when it comes back to them, they should be quite excited. That was a, would you believe?
Yeah, well,
question.
yes, I would believe that.
Yeah.
I'm going to hand out the findings pages. So I have one for each of you. And I also have the report for the clerk, okay?
Good, thank
so
you.
I will bring this up. And I will answer questions if you have any. There are a lot of people
Questions
to
for the
testify.
representative. Representative Raymond.
Thank you, Mr. Chairman, and thank you, Representative Wallner, for taking my question. So I was trying to remember last year all of the discussions we had about this bill. And one of the questions that I had last year, and I still have, is about circumstances where the child's parent or some other relative is already the payee for the Social Security benefits and is using that money to pay for things like the family's rent so that the child has a place to come back. Would this bill interfere with that process? And then secondarily, if the circumstance were to arise where the payee ends up being changed to the state, well, just that one, would that interfere with it?
Well, it would mean that the benefits would be preserved for the child by the state, and the state would no longer take those benefits for the state's reimbursement for the foster care. You will see that there is one small difference in this bill than there was last time. And we added, and I don't have the bill up here with me, but we did add a section that refers to if a child goes into foster care and they already have a payee, might be a relative, a family friend, a grandparent, if the child already has a payee and the state determines that that is an appropriate payee, they could retain that payee while they are in foster care. And that would avoid the state taking the Social Security payment.
So thank you. That's where I was trying to go follow up. So in that circumstance, would that payee still have the ability to use those funds to maintain the child's existing, household of origin, or does that payee then have to create a savings account for the child with those funds?
I think that would be something that I would imagine that the Department of Health and Human Services would work out with the payee. I mean, in some circumstances, if the child has had these Social Security payments and the family is very low income and they may be using part of the child's Social Security to help pay their rent. If you really want to reunify the family, you don't want to impoverish them in such a way that they couldn't accept the child back into the family. So this could benefit the reunification of families by being sure that those resources are preserved with the family.
Thank you. That's what I was trying to get clarity on.
Thank you.
Any further questions for Representative Wallner? Seeing none, thank you so much. And, every one of these cards, with two exceptions, says you want to speak for 3 minutes. And the two exceptions say 2 minutes. And since we've got other things we got to do this afternoon, I'm going to hold you to 3 minutes. When you hit 1 minute, I'm going to go like that, which is not a sign that I'm smarter than you, believe me. And then 2, and then I might give you a 30-second warning, let's say. That's just so we can keep things moving along. Chair recognizes Karen Rosenberg from the Disability Rights Center. And I did have one question for Representative Wallner. Do you get mileage? So like Jim McKay, huh? Yeah. Yeah.
You.
Did I get one? I don't think I got one. I didn't get one. I want one.
Good afternoon, Chairman Pearson and members of the committee. I'm Karen Rosenberg. I'm the Policy Director of the Disability Rights Center of New Hampshire, and we are here in strong support of this bill. As you've heard from Representative Wallner, HB 661 would require the Department of Health and Human Services to help parents apply for benefits for their children or apply for federal benefits for children in their custody, and then require that those benefits be conserved. They could be used for current needs that exceed what our foster care system generally covers for children, which for children with disabilities could be things like extra supports and respite in the family home, the foster family home, that aren't generally covered by the regular foster care benefit or system or not covered by Medicaid. It would also require the department to allow those benefits to be conserved for the child for their future use. For children who have disabilities and are eligible for SSI or Supplemental Security Income, that is a income-based disability program for children and adults, but it has a resource limit. Those funds could be conserved in an account called an ABLE account, or sometimes referred to as a stable account. Very easy to use. Our state has one, and that the money could be saved for future use and without impacting a child's eligibility for continuing SSI benefits. The reasons we think this is really important policy for our children is that we expect significantly improved outcomes for children who have contact with the foster or the DCYF, for children who are removed from their parents, for children who ultimately age out of the system. The best outcome, of course, for children when there is a suggestion that they might be subjected to some abuse or neglect would be for the family to get the services they need to stay intact, to not have the children removed. Having those benefits available, helping families to apply for these benefits can help maintain family stability, help them maintain food and nutrition and housing for the child. If children need to be removed due to safety concerns, having those benefits available can help with reunification or also help entice a kinship family to actually house a child, knowing that they can get the respite they might need for a child with disability or other services or supports that they would need to maintain the child safely.
30 seconds.
Oh my goodness.
I know.
So I have provided two documents for you. One is from Casey Family Services, which is a chart that outlines children who exit foster care, what our homeless rate is compared to the rest of the country. And you'll see that right now, 45% of New Hampshire children 19 years old exit the system homeless. This would prevent that from happening. I've also circulated testimony from a youth who was in foster care, Kamaya Lockett, who couldn't be here today. She did experience homelessness and is eligible for SSI benefits and would not have experienced homelessness with these benefits. I noticed the not so subtle hint, Chairman Pearson. I'm happy to answer any questions and encourage you to support this bill.
She's very happy because your Eagles just won the Super Bowl.
She is too?
Yes, don't speak Philadelphia, not in my committee. Okay, go ahead. Representative Raymond.
Thank you, Mr. Chairman, and thank you for that. I don't actually know about the Eagles, but I'm happy for anyone who's happy. Can I just ask about the chart you gave us, which is from 2021? Is that when the data is from 2021?
That's the most recent data. I accessed it today, actually. It was dated it actually has a date of June 2024, so when they published it.
Okay. So
Yeah.
does that mean that almost half of the kids who are leaving foster care don't have a place to go when they walk out at 18 or 21?
Not necessarily. It means that they, during some time between the ages, in this chart, between the ages of 17 and 19, they experienced homelessness. So maybe they had a place to go right when they exited, but then they didn't have a place during the interim couple of years that this reports on. And it doesn't mean, just to be clear, that they necessarily were eligible for SSI. It just shows this is just one outcome point for our children in foster care and something this bill could do to prevent this kind of outcome.
It's horrifying. Thank you.
Any further questions? Seeing none, thank you so much. The Eagles are the Philadelphia Eagles, and they won the Super Bowl yesterday.
Yeah, I'm not really a sports ball person. Good for everybody else, though.
You two can talk later. Chair recognizes Stacy Phillips. And we got 3 minutes.
Okay. Now I have 3 children to talk about, so I'll try.
Okay.
I am here to talk about HB 661. My name is Stacy Phillips. I live in Manchester, New Hampshire. My husband and I were foster parents from 2004 to around 2011. During this time, we fostered around 73 children. We were trained as regular, specialized, and an emergency home, and we did respite. We adopted 2 children from foster care. I also feel it's important to share a little bit of my background because I feel it gives me a unique look at this specific situation and legislation. I have my associates in early childhood education, human services, and a bachelor's in psychology with a minor in education. I worked 10 years as a preschool/kindergarten teacher, 4 years as a paraprofessional to special needs children, and I currently work for the state as a disability examiner working for Social Security Disability. So, very wide gamut. My youngest adopted child was placed with me at 8 months old. She was failure to thrive, could not roll over, sit up, hold her own bottle, or feed herself. She was severely delayed in developmental milestones. While under my care, she slowly made gains, but was nonverbal still at 2. Knowing what I know now, she clearly met criteria for Social Security disability. The regular foster care stipend was all we received for this child for most of her time in care. The stipend did not remotely cover the extensive things this child needed. The $300 sensory swing that hung in our hallway, the stretchy sacks, the weighted blankets are just a few of the things that we had to pay out of pocket. I also had to drop down to part-time work because of OT, PT, speech, IEP meetings, blah, 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 blah. Her aggression issues would rise to the level that windows and furniture would be broken pretty much on a monthly basis. We knew the day we adopted her that she would likely never live without her support, and we would need to plan for when we leave this earth. Having disability funds would have helped greatly offset the out-of-pocket expenses to meet just her basic needs. Never mind plan for the future. As foster parents, we had no right to apply for Social Security disability. When she attained age 18, I did apply for adult child with a disability survivor's benefits under my late husband's Social Security record. She was found meeting criteria for autism and was allowed disability benefits, which supports my theory that she would have been allowed as a child. My other adopted child came to us. She was in care for 2+ years before she was adopted. We found out the state was receiving her benefits from Social Security during this time as her biological father was disabled. She was placed with us. She was very parentified, having raised herself. She also struggled with trust, self-confidence, and safety awareness. We tried to reclaim some of her childhood with camping, summer camp, and dance classes. All of these things came out of our pocket, with some exceptions with grants for part or all of camp. Dance class was especially helpful in helping her reclaim her self-confidence and self-worth. All these things, dance class fees, school trip fees, amusement park entry, birthday parties.
Half a minute.
All came out of our pocket. They weren't covered by the stipend. And then my last child I'd like to talk about was 9 when he was placed with us. We wanted to adopt. However, the state wanted him in a group home with his brother. He aged out at 18 and was homeless on the street when he reached out to us. We helped him as much as we could, getting him connected to Job Corps, New Hampshire Health and Human Services, and other services. He happened to mention to me that Social Security was taking him to court for an overpayment of Social Security benefits, despite him never having received Social Security. With his permission, I investigated. Come to find out, the state had been getting Social Security for him for years, money which he never saw.
I'm going to now ask if anyone has questions for this witness. Yes, Representative Raymond.
Thank you, Mr. Chairman. I have a question. What happened with his Social Security lawsuit?
So the state, I called Social Security and I called the fiscal agents at DHHS, and they turned around and went after the state for to reclaim the funds instead of the money that he was owed. So in the end, he did not have to pay for it. I guarantee there were many others that did, though.
Any other questions? Seeing none, the testimony you were allowed to give was compelling. Thank you for coming. Chair recognizes Megan Dillon from the New Hampshire Legal Assistance.
Can you hear me? Sorry. I always forget how the button works. I'm Megan Dillon. I am a non-attorney advocate with New Hampshire Legal Assistance. I'm also the Public Benefits Project co-director for New Hampshire Legal Assistance. I've spent the bulk of my career with NHLA representing individuals and children in federal disability claims with the Social Security Agency. And to answer some specific questions about the RET payee, I wanted to address the specific piece that we added to the bill about the suitable RET payee, because primarily this is already embedded in the federal regulations, and I've handed out the Social Security POMS, the Program Operations Manual Guidance, that outlines how the agency is supposed to vet and assign an appropriate representative payee for children in foster care. And primarily the federal regulations already outline that the state or the agency with custodial care is not the automatic representative payee and should not be. It actually says should not and not automatic throughout the federal guidance. There should be a thoughtful process as to who should be the appropriate representative payee for children. And there's a preferred list of representative payees, primarily the legal guardian, parent, if not step parent, and beyond that, it could be someone who has a vested interest in this child who doesn't have custodial care. That could be an older sibling, a grandparent. There are many people in these children's lives. Just because they're in care doesn't mean they don't have someone with a vested interest in this child who could have been conserving the funds the entire time. We have an example of one of those children in the room today. That exactly happens. So in these instances, frequently the state was automatically assigned or applying to be the representative payee, and there was very little happening related to them searching out a potential other family member or person with a vested interest in this child. Many of these children could have had funds conserved the entire time if that person with the vested interest had been doing it. And to answer your questions about spending related to conserved funds or funds for the beneficiary, it is built into the federal regulations that the mission of SSI survivors, SSDI for children, is for the benefit of the child's interests, the child's needs. Those funds are to be used towards the interest of a child. Many of these children identified for these very strict benefits and disability criteria are also identified for special education. And as we know, these children are required to have a transition plan. The transition plan is usually and hopefully reunification, which means they can work with the agency, the federal agency, to ensure that needs of the child means conserving those funds for the family to allow that child to come back to a home that is complete and current on rent and current on mortgage, because the plan was for the needs of the child going forward to be unified with their family. That is something I've seen in my work. That's something that I've seen with children that I have set up, that we have assisted, who have accounts set up who are conserving funds and searching for that appropriate RET payee for those children.
Wrap it up. Or did you?
I did.
You know,
Look
that
at
was exactly 3 minutes.
Woo!
I grant you 10,000 international units.
Oh my goodness. Well,
My
thank
wife
you.
and I do that. She says, where's the catalog to redeem them? We don't have it. If you find it, let me know. Any questions? Seeing none, thank you so much for coming.
Thank you.
Next up is Aubrey Friedman. Oh, thank you. Save those thoughts. Next up is Marie Noonan and Susan Larrabee from DCYF.
Good afternoon, Mr. Chairman. Good afternoon, members of the committee. My name is Susan Larrabee, and I am General Counsel for DCYF.
Good afternoon. My name is Marie Noonan. I'm the Division Director for DCYF.
And in response to being as brief as possible, we did pass out the actual report that was mentioned by Representative Wallner. And again, by way of procedure and by way of confirming what this is, last term in the Finance Committee, House Bill 1598 was amended to result in DHHS be given an appropriation to hire a public consultant to study our process of conserving and managing funds, to look at our process, to dive into what it means to have a child-centered benefits and management of federal funds, because it's a very, very complicated process. Anything with the federal government, especially Social Security, is very complicated and has a lot of nuances, especially at this point in time that it is at the precipice of what many states are looking at. Arizona was the trailblazer 2 years ago with their legislation. Last term, Massachusetts did similar legislative acts to conserve federal benefits for kiddos. That is also mentioned in the consulting report. I do ask that everyone read that report. I think it's a wealth of information, especially in explaining a very, very complicated process.
Thank you.
And it actually slides over.
Thank you.
Welcome.
Thank you. I would also like to add that currently there is cost associated with making changes to the state having access to the child's benefits to be able to pay for costs for their care. DCYF certainly does not disagree with wanting kids and families to have all the benefits, all the resources available to them, as certainly as they reunify and certainly as they prepare for adulthood. We certainly agree with that. But I do want to note that it is not included in DCYF's agency budget to be able to absorb the cost that you will read about in the report. So we don't disagree with wanting kids to have what they need, but we would have to have some appropriations attached to be able to adopt this change.
Any questions? Representative McMahon.
Thank you, Mr. Chairman. Is it Ms. Noonan?
Yes.
Okay, want to make sure I had it right. Specific to what you just stated, what's the cost of doing nothing?
So the cost of doing nothing would mean that children, the state would continue to become relative payee in some instances and use the cost, use the child's benefits to reimburse the state for costs associated with their care, which is what the benefit is allotted for. And so if we were to adopt the changes in here, there would be a loss in revenue to the state as a result, and we would need to be able to have the funding to be able to offset that.
Representative DeSimone.
Thank you, Mr. Chairman, and thank you for taking my question. So if you have a child in the foster care program who is not receiving any benefits whatsoever, who reimburses the state?
Children are often eligible for 4E, and they still may if they are entitled to Social Security benefits. So 4E may be a reimbursable service, and otherwise we have general fund dollars.
Follow up?
Follow up.
And in some instances, I should say also Medicaid, depending on the type of placement.
Thank you. So if a child does not have any other income, whether it be disability or any other income, nobody reimburses the state for the foster care. Is that correct?
So again, if they're 4E eligible, there could be 4E reimbursement. And for some types of care, Medicaid is also used to reimburse.
Final follow-up.
So if that's the case with that child, then why should a child's disability stay with the state and can't be used for that child? What makes that child different? Why can't the money be saved for that child to get a leg up when they age out of the foster care system?
Thank you for that question. And we agree, again, that we would want kids and families to have all of the resources financially and otherwise available to them. So the Social Security Administration has certain criteria for what the benefits can be paid for. So relative payee, and I realize we heard testimony to the contrary, but my understanding is that relative payee is for the person or the entity providing care for the child to be able to pay for costs of caring for a child. There is a waiver process in place. So for example, if a child were to leave a parent's home and they were eligible for benefits and the parent now loses the benefit of that, they're able to appeal that decision to the Social Security Administration to not have the agency become the rep payee.
Thank you.
Representative Rice.
Thank you, Mr. Chairman. Thank you for taking my question. So what is the cost to the state when this child gets out of foster care and is left homeless, and then the cycle continues and you end up with their children in foster care?
So currently we do hold the benefits for a child that is preparing to launch into adulthood for about 6 months so that they can accumulate certain dollars as they leave so that we can try to support their care. In terms of costs once a child leaves the system, I'm sorry, I don't have the answer to that question.
And in the report, especially on pages 3 and 4 particularly, the group, the public consulting group, who met with us for various interviews, reviewed all of our policies and procedures and evaluated our current system. They do point out our program strengths, which already is doing a lot of child-centered conservation and management of funds, especially for that very vulnerable group, that 14 to 17, and also mentions as another strength the receptiveness of the legislature here in New Hampshire to that vulnerable group. They point to the legislation last term that made it possible that 16 and over kiddos in care can open up a bank account on their own, can open up their checking account on their own with certain income maximums, because again, SSI says you cannot have more than $2,000 in income, to make them more financially ready for adulthood, to stop that cycle of leading into homelessness, and again, for those very vulnerable group. And as Director Noonan pointed out, that we are already earmarking those children who are about to become adults, getting them hooked up with SSA on their own so they can become their own rep payee come 18 years old.
Follow up?
Kind of a follow-up, Mr. Chairman.
Kind of follow up?
Jeepers. I was like, here I go again. So what would your response be to the wonderful woman that fostered those children, and really, thank God they had the money to pay out of pocket for the needs of that child? How do you justify that money not going to that child for their needs? Because fortunately they could afford it. Someone else may not have that, and then that child suffers.
Thank you for that question. And certainly I empathize with families providing for children and youth with disabilities, with challenges. And I again, I'm very sympathetic to that. The Social Security allows the benefit to be used for costs associated with the care and the needs for the child. And so as the state agency, when we're providing for the care and for those children, that is why we're currently taking those dollars and reinvesting it in the children's care.
Representative Gregg.
Thank you, Mr. Chairman. I'm trying to think because she pretty much took most of my question. So is there a reason in a case, and I want to go back to the foster mom that we heard from because that's our on the ground firsthand experience. Can you explain why she would not have been able to get those funds for the child that obviously had some needs that that could have helped with? Because I'm confused as to why that didn't happen.
I'm not familiar with her case specifically, but if I understood her testimony, it may have been that the child was deemed eligible later. And so one might think that she could have been eligible as a younger child. One of the things that we appreciate in this report is some of the recommendations made to the state of New Hampshire, one of which is that we could increase the screening, and we agree with that. That is a step that we can certainly take that doesn't add additional costs. It's certainly, we could absorb that as a DCYF agency and be able to ensure that when kids come into care, we have DCYF nurses, thanks to the legislature, and the kids that come into care also get medical screening and behavioral health screening, and we could use that to determine potential eligibility.
Thank you. So just to follow up with this, putting this into practice would then help situations, could very well help situations like hers where she was trying for when the child was much younger to be able to get that. Okay, thank you.
Representative Raymond.
Thank you, Mr. Chairman. So my question is just that the report didn't make its way all the way around the table. So is it in electronic format or some other way that those of us who don't have it could get a copy? Because I'd very much like to reference it.
Yes, we can get that.
Thank you.
5 more, yeah. Representative George.
6 more.
Thank you, Chairman. I don't know because it's someone who asked me one day, they was taking 3 children, but they didn't want to give them any benefit, but they need to support the children by their own. And they told me how they can do that because the 2 parents cannot be with the kids.
Make it a question, please.
Yeah, my question was why they cannot give them the benefit, why they cannot even support, why they can have a benefit like to get or food stamp or something. They said they cannot give it to them. Why? If already this is because I think so. This 6611, I can support that.
So once a child comes into out-of-home care, the family is no longer providing for the care and support of the child. And that is why the state becomes representative payee. Again, I mentioned, it's my understanding families could ask for an exception to that, as can a relative, if they were receiving payee at the time the child came into care. But at that time, the state is then preparing or providing the care for the child, and so is then responsible to accept those dollars.
Seeing no further questions, thank you so much.
Thank you.
Chair recognizes Dawson Hayes for 3 minutes.
Hello, Mr. Chairman and committee. I want to thank you all for allowing me to speak today. I'll try to, make it quick. My name is Dawson Hayes. I was a part of DCYF's foster care system from August of 2021 until I was adopted last year. For 3 years, DCYF pocketed my Social Security payments, keeping a total of $16,000 that was intended for me. This is a common practice for foster kids whose parents are disabled or deceased. This is unfair because DCYF already receives government funding for the care they arrange for foster kids like me. I wonder why only the foster kids who are entitled to Social Security or veterans benefits are essentially forced to pay for their own foster care. I was told by my caseworker that the money was kept to pay for the care and services I received. I have to say, I certainly did not receive an extra $16,000 worth of care and services. Foster kids need every advantage they can get, and this obviously includes the Social Security or veterans benefits that are intended for them. According to the report that was recently completed, a lot of foster kids have these payments taken from them by DCYF. This practice must stop. Fewer than half of foster kids even graduate high school, and only 3% graduate from a 4-year college. In fact, 22% of foster youth experience homelessness within their first year out of care. Considering these facts, it seems incredible that DCYF keeps any of the money that would actually go a long way towards helping the foster kids. I think the money should be saved and put into a high-yield savings account for the children to have when they get out of foster care, for a jump start to help with the cost of transportation, food, etc. My own sister aged out of foster care. Luckily for her, my adoptive parents bought her a brand new car so she could get a job and not struggle with transportation. But without this, she would have had no way to get a job and keep it and earn money. This is the reality for most foster kids who age out. They have no resources and no way to keep a roof over their heads. That's why so many end up homeless. The thing is, this money can mean the difference between being able to support yourself or ending up on welfare and food stamps for survival. If you want foster kids to grow up and be independent and self-sufficient, they should be given every bit of help to start with their adult lives. $16,000 might not seem like a lot of money, but to a foster kid, I promise you it truly is. Again, thank you for allowing me to speak today. If anyone has any questions, I'm happy to answer them to the best of my ability.
Any questions? Representative Gregg.
Thank you, Mr. Chairman, and thank you for being here. Would you believe I don't have as much of a question as thank you for articulating that so thoughtfully and so well and really speaking to your cause. Truly, you're a remarkable man, so thank you for being
I
here.
appreciate it.
Thank you. And the next time you come, I owe you 24 seconds.
Thank you, Mr. Chairman.
Thank you. Chair recognizes Cassandra Sanchez from the Office of the Child Advocate, who wants to speak for 2 minutes. She said it. Let's see. With Lissa Mascio, handing out things.
Yes. And I may even be able to be briefer now because that was so beautifully said.
Wasn't it great?
Yes, it was wonderful. So for the record, my name is Cassandra Sanchez. I am the child advocate for the state of New Hampshire. And I am here in support of House Bill 661. I agree with the testimony before me in support of this bill. And I do just want to add a little bit of my experience in working in Massachusetts with children in the system and their Social Security funds. When I worked for the state of Massachusetts, which I left in 2021, we at that time already had been conserving funds for kids in care. As already explained, it could go up to the max of $2,000 at any given time. And then as social workers, we were responsible for spending down their funds on something that they needed. I can give you a couple of examples of items that we would get for children. Oftentimes, particularly for middle school or teenagers, laptops so they could do homework at home, that they could do job applications. And this is something that would carry them through, typically through college as well. The laptop was purchased early on and in good quality. They can preserve that and then use that in college or in their future career. Also, children are children. They want to have nice things like their peers have. And so we would have kids that wanted really nice sneakers, but we could not expect foster parents to foot that bill because they were already paying so much to be able to provide the day-to-day care. And so to be able to gift a child a pair of Nike sneakers that they want around their birthday time because they have the funds there available to them, it was giving them a sense of normalcy. And that sense of normalcy has a true impact on their long-term outcomes because now they don't feel different than, they're not marginalized, and they do feel like they can amount to something someday. Other things as mentioned already, intensive therapies that are not covered by insurance, devices for children who have disabilities. We recently had a call to our office about a kiddo in care who had a communication device that was broken while they were at their facility. The facility did respond appropriately and immediately reached out to insurance, but that left that child without a communication device for almost a month. And then they were having visitation with family. And during that time, they could not communicate with their family, which created more outbursts and difficulties in their visitation. And ideally, that child should have had that device immediately. If those funds were available, that could have been purchased by the division, and they could have that even as a backup device in the future. So there's so much that can be done with these funds. And for that reason, we are in support of this bill.
Thank you. Any questions for OCA? Seeing none, thanks for coming again.
Thank you very much.
Chair recognizes Emily Lawrence from Waypoint.
Good afternoon, Chairman and members of the committee. My name is Emily Lawrence, and I'm the Advocacy Director with Waypoint. Waypoint is a nonprofit organization that works with children that are involved with the Division for Youth and Families in a couple of different ways. One is that we provide in-home services, supports and services for court that are court ordered when a child comes into the system. And then also when a child exits the system, we often provide services through our homeless youth and young adult programs. And so what I'm passing out to you today is actually testimony that was written by our program director for the homeless youth and young adult programs. She was not able to be here today, but we wanted to share some of her experiences with these young adults who age out of care, often into homelessness right when they age out, or may experience homelessness several years after. I think there are several examples that we put in the letter, so I don't want to belabor that, but just to say that there are countless stories that she has seen of young people coming in who have, as I said, aged out of care. We cannot confirm whether they would have been eligible for SSI or not, but even if we took a fraction of those, it would still be a significant number of kids who could have benefited from that money to help them with things like even basic urgent necessities: clothes, food, shelter, a phone, and then more long-term as well for education, helping them to find a job, and just to connect with other people in their community. Transportation is another need that we see frequently. So we are in strong support of House Bill 661, and we hope that the committee will pass the bill. I am happy to take any questions. Thank you very much.
Gosh, I got to think of something.
That's
Thank you so much.
sure. Thank you.
Next up is Robert Tangway. And you, sir, have 3 minutes and 17 seconds because you were so on the good clock last time. Remember I told you you had 17 seconds in the bank? So 3:17 for you, sir.
Mr. Chair, I'd appreciate some interest on that. Inflation is very high. My name is Robert Tangway. I don't know too much about this bill, but I was listening to the testimony. I'm kind of getting warmed up for what's going to be happening in the future today. I'm the author of New Hampshire Oliver Twist, and if you guys have read or heard of Oliver Twist, it's a story about an orphan who is abused by everybody who is around him with officials. The gentleman's, young gentleman's testimony earlier was very relevant to what's going on. I mean, I'm looking at a U.S. debt clock, and I don't know if the committee knows that every single citizen in this room, everybody has $75.6 thousand in debt. So that young gentleman was born with $76,000 in debt. And then when you look at a family of three that owns a house with half the equity, and the average house price is $500,000, a person who has a family is actually in the positive. I didn't get that. Luckily, I had a mother, and I'm very thankful for that. So what we have with this bill, it seems like they're intercepting, the state is intercepting funds and taking it away from the people who actually deserve it. We're born with equal access to all of the state's resources and the country's resources. And I think that that's something that's very important for a young disadvantaged youth to be able to have available, or a foster parent to have available, so that they can go spend it at Canopy Lake and give the child something that, and then it goes into our economy. So it's really just redirecting the funds to the state, which is, I believe, the state's largest employer is the state, and then taking it away from disadvantaged youths. I will ask for some leniency on my time, and I don't think that there are any questions that need to be asked. I will note that I watched every 0.5 seconds the national debt go up $16,000. Thank you.
Put 47 seconds in Mr. Tangway's bank. Thank you. Chair recognizes Emma Savini from New Futures.
Good afternoon, Chairman Pearson and honorable members of the committee. For the record, my name is Emma Savini. I am the Children's Behavioral Health Policy Coordinator at New Futures. New Futures is a nonprofit, nonpartisan organization that solves problems through policy change, and we are here in strong support for Senate Bill 661 today. We're here in strong support of this bill because it ensures that foster youth have access to concrete supports, either during their time in foster care or after, which is a proven way to reduce the impact of adverse childhood experiences and give them the best opportunities to succeed later in life. Countless studies have shown the impact that toxic stress can have, not just on a child's mental health, but actually in the physical brain structure they have. When kids are exposed to traumatic experiences, which many in the foster care system have been, these adverse childhood experiences can have really long-term devastating health consequences. Higher rates of heart disease, diabetes, depression, suicidality, anxiety, the list goes on and on. Providing concrete supports is a proven way to mitigate the impact of ACEs. ACEs can be mitigated by protective factors, and then well-being can be improved by promotive factors. Concrete supports are both. So not only does this stipend of money that the children have access to during foster care and afterwards have a protective ability on the child to make sure that their ACEs scores do not impact their health, it actually promotes their well-being. Studies have shown that when kids and families have access to finances, they have higher rates of long-term stable employment. They have long-term better health outcomes and mental health outcomes. So for all of those reasons and all of the reasons that other folks have so eloquently put, New Futures urges this committee ought to pass on this bill. Happy to take any questions.
Any questions for Ms. Savini? Seeing none, thank you, and my love to Chloe.
Thank you.
You're welcome. Seeing there's no more pink cards on this, I will close the hearing on House Bill 661. And we will have to exec this the first session in March because it's an early bill. And then on to finance. Thank you for coming. We're going to take about a 2-minute rest here while some folks are leaving, others are finding seats. Everybody. Okay.
To the chair.
because of the number of the pink cards. I just want to let everybody other than the prime sponsor know you are going to get 3 minutes. Otherwise, the doors shut of the building at 5 and you will be shut out. You will have wasted a day off of work and you will not have testified. And that's not a threat. That's just how the clock works. So I've got a mitt full of pink cards here. And some of you realistically asked for 3 minutes, except for one who did 2 minutes and 30 seconds. I love you. Thank you. So that if you have written testimony that you're going to read, you may want to take out adverbs and things like that. Chair recognizes, open the committee hearing on House Bill 652. And Representative Bernardi, I'm going to give you 10 minutes.
Thank you, Mr. Chair. I'm not sure I can get through all this in 10 minutes because this is a huge responsibility. Thank you, Chairman. Thank you, committee. I'm here to introduce HB 652, which is to abolish the family court. And I start off with the rationale of why this is necessary. So family court was established in 2005, so it's been in existence for 20 years. And yet it is antithetical to two constitutional provisions, Article 15 and Article 20, requiring that any litigants be given the opportunity of court in equity, as well as two statutory requirements, RSA 490D3 and 491.14. In point of fact, people get shunted to the family court through RSA 491.1 and 2. So the family court has generally been not generally been adjudicated by judges. The presiding officer is often a marital master, now called a referee. As such, they are not constitutional officers. RSA 490D8 defines the qualifications of a marital master, that they have professional experience in family law of matters, knowledge of family matters, personal maturity, personal qualities of patience and understanding. Fine. Okay? So in 2007, I'm trying to shorten this up here. The Senate brought a question to the Supreme Court, and it was defined that marital masters are not constitutional judicial officers. They are further not subject to the New Hampshire Judicial Code of Conduct, like other constitutional judicial officers. They are generally not attorneys. Therefore, the Bar Association has no jurisdiction over them. Ultimately, in most cases, there is no official mechanism to address their accountability. In hearings, witnesses are often not sworn in. Hence, there's no pursuit of perjury. Family division is known in the public as the liar's court. The facade of being a judge is maintained by placing the court in a court facility and requiring by law that the presiding officers wear official black robes. As mentioned, marital masters' orders are only recommendations. To make them legal, they have to be countersigned by a constitutionally appointed and qualified judge, RSA 490D9. All recommendations of marital masters shall be signed by a judge. The judge signing such recommendations shall certify that he or she has read the recommendations and agrees that a marital master has applied the correct legal standard to the facts determined by the marital master. In 2007, administrative judge of the family court, Judge Kelly, proposed an amendment in the Senate and to repeal that requirement, that these orders be countersigned by a judge because, quote unquote, it is virtually impossible for a judge to spend the time they have going through the file to really get an understanding of the case, to measure the case against the facts that they have found, that were found by the master. It is virtually impossible, I think, without sitting in the courtroom and seeing the witnesses and judging their credibility and listening to all the facts of the case, for a judge to second guess someone who has just done all that is not really a review that occurs right now under the law. It is a signature. It is a co-signature to the master's report. The 13 February hearing results. The bill was not adopted, yet all these inadequacies and deficiencies of the system still remain. One would expect the rules of the circuit court family division should be consistent with the rules of the other circuit courts in law and equity. However, Rule 1.2 states that the family division may waive the application of any rule except where prohibited by law. Rule 2.2 indicates New Hampshire rules of evidence do not apply. In case after case, you have heard litigants claim their ability to present evidence or gain discovery has been seriously and severely hampered because Rule 1.25 states the court in its discretion may limit or expand the scope of discovery in any case as justice requires. The ability to present evidence and make discovery is critical to establishing one's case and is repeatedly being denied by this system. Litigants are not informed of these deficiencies. There is no informed consent that they're waiving their constitutional right to a trial in equity and that they're submitting to a quasi-judicial review and findings of facts by individuals who are not constitutional officers and therefore have no right to judicial conduct review. Their only appeal is to the New Hampshire Supreme Court, where findings of facts are not reviewable because the Supreme Court's only looking at the law as applied to the facts that have been found by that marital master. This past year, recent session, the legislature repealed the Judicial Conduct Commission, which was established in 2010 to rectify this problem, because there was one clause in that law that was found to be constitutionally deficient. So now there is no opportunity to rectify this problem. So these deficiencies indict the family court system as it currently exists. It's basically that worm being eaten by an apple being eaten by the worm, except there are way too many worms. How do you know the harm will continue? Well, you're sitting in a committee that's dealing with those harms time after time, day after day. And there were established 2 special committees to also deal with these problems. I sponsored H.R. 14 2 years ago, creating one of those committees. The thought was the victims would come before you and make their case. And then you could bring the family court judges in to hear what their rationale was. You could do that. You are as qualified to be a family court judge as they are. I read you their qualifications early on. You meet all those qualifications. You could have made those judgments. Instead, the work is focused on training, staffing, and other issues, not dealing with the fundamental deficiencies of the system as a whole. More Band-Aids on the corpse. I believe the actual review of cases is necessary to determine whether the family court judge should be removed. An actual review would demonstrate a pattern of violations or abuses. You're not going to catch any hidden envelopes or any other nefarious activities. But if you listened to the cases and reviewed case after case in those special committees, you would have found patterns that have come before you already. Alienation of affection claims, reunification therapy with abusers, evidence of covert surveillance. I gave this is new, I gave the chairman a document here where there's a little screenshot that indicates someone has tapped into someone's private Zoom meeting that turns out to be linked to a family court judge. There are more of those kinds of activities. They only come up quickly. It's hard to get a screenshot. We were lucky to get one here. We have a system that fails to permit testimony, as I indicated, by the rules. You have a failure of BCSS to follow Supreme Court decisions. You have had testimony early on where a victim came before you and explained she went to the New Hampshire Supreme Court 5 times.
I'm going to give you 2 more minutes to wrap it up.
Well, then I cannot begin to go through this and fully explain the problem of this. I mean, Mr. Chairman, the family court system is broken. It is fundamentally broken. You know that. Members of this committee know that. You hear these cases day after
Representative,
day.
we are prepared to speak for ourselves and not have you speak for us.
I'm speaking for what I have observed.
That is your opinion.
It is my opinion. Yes, indeed it is. So I will turn then to the provision I provided, which the greater provision, which is the explanation of what the recommended changes are. Fundamentally, you see that I have basically sent most of the activities of the family court back to the Superior Court. That's where they were before 2005. If you look at the first page of this document, towards the bottom, you see jurisdiction D.2. You see subarticles 1 and 2. Those are the articles that I have offered a mediation program to deal with. Articles 3 through 10 go back to the Superior Court, or in some cases to the probate court where they originally were. Why a mediation service, and what kind of mediation service am I proposing? Well, the mediation has been used by multiple courts in other states already, and that's where I drew this idea from. It is less costly than the current system. Furthermore, I have placed controls here where the mediation system is to be conducted in accordance with guidance by the Academy of Family Mediation Professionals. They have standards on training. They have standards on qualification. They have standards on quality assurance, and would therefore assure that mediators in the program are not putting their thumb on the scale. I can't make it shorter than that.
Any questions for the prime sponsor? Representative Raymond.
Thank you, Mr. Chairman, and thank you. Are there any states currently that do not have family court?
I don't have a full understanding of what system is in every state. Every state is different. So they may have family courts that are part of their Superior Court system, as a division or a separate entities. Some go directly to mediation as a matter of law. It varies state to state.
So follow up. Are there any states that use mediation in the cases of child and abuse and neglect cases?
I don't believe so, and that's why I have, if you look at the Articles 3 through 10, the neglect cases, the abuse cases, those types of cases, I've said they need to go to Superior Court. You need to be in a court of equity for that.
Thank you. I appreciate it.
You had said earlier that I was as qualified as a family court judge, and in my fantasy life I am, but I don't have a JD. They do.
No, they don't. You do not need to have a JD. It's not a requirement.
Most of them do. Family court judge?
They are not required to have a JD. They're not required to be a member of the Bar Association. I read you the requirements. Get to my notes. I can give you the citation of the qualifications are found in RSA 490D8.
490? Okay, look at
490D8.
Thank you.
So There's no one on this committee that I believe that does not have the capability of standing as a family court judge. And therefore, you have the full ability to review and evaluate the harms that you have heard, and then ask the judges that made that decision to justify those, if they make sense. You have the common sense ability to understand that decision doesn't make any sense. Why are you putting this child back in the hands of an abuser?
I have another question for you. What would be the benefit of creating a second mediation office since we already have one?
The reason I created a second mediation office rather than take the current one is because the qualifications to be a mediator are not well understood by me in the current system. I gave you this handout. It lists a particular person who is a mediator and a family court judge, and on his advertisement, he advertised that he handles cases with high net worth personnel. That is not someone who is a neutral party. That is someone who's going to put their thumb on the scale in the favor of selected individuals. And I don't want that mediation and arbitration group to have anything to do with family mediation. That's why I separated it. Now, that's not to say that you couldn't adopt the standards that I have put into the legislation from the AFMP, excuse me, and require all mediators to meet those requirements, and that would potentially take that individual and individuals like that out of circulation. But that's the reason.
Given the statements that the special committee heard that some family court judges then rotate over to probate for a while and they're not especially trained in family law, even though one of the small victories the special committee got was further training for our judges now in family court, what makes you think that kicking things up to Superior Court, which I see in here numbers of times, would find a judiciary any more qualified or trained in family court matters?
Because in Superior Court, one has to follow the laws of equity, meaning you have to have full due process rights. In the family court, as I went through, those are gone. There are none available to you.
I think the rules of evidence are discretionary. They're not absent.
It's not just the rules of evidence. It's far beyond the rules of evidence. And when the quote-unquote family court judge can decide what evidence they're going to listen to, and someone wants to present, well, here's the circumstance of my case, yet they're not heard, that opportunity is foreclosed. And there's no reason that they can be given an opportunity to make their case because the family court judge says, it's not important. That's not going to happen in a court of equity. Anyone has full opportunity to present their case. All issues will be heard.
Okay, looking to see if there's any other questions. Representative Gregg?
Yes, I wonder, in understanding in depth how family court works and how they have to go about certain things and also the complications that come in, how do you suppose that putting it in mediation so that people can have all of their information put out there, when we have people come in here and they have stacks of stuff, first stack is like that, how do you suppose that they handle the workload in this state, and what do you think the backlog would be to put this all in this situation or give it to the Superior Court?
Well, first off, I recommended that the phase out be through 2 years, and I'm going to further recommend to this committee that if you realize that this kind of approach is a necessary approach, that you may start just like the family court did in 1 or 2 counties. Trial the system, work any bugs out that may exist, and then expand it to the rest of the state. That is not in here, but the 2-year issue is in here. the number of cases of divorce and child custody are not going to change. I don't think we're changing our climate and our culture. So the same number of cases appearing in family court are going to actually appear either in mediation or a choice to go to Superior Court. And that's the choice that I give. Anyone coming before the court saying, I'm seeking a divorce, you get to choose. You get to choose a court in equity, or you can go to mediation.
If at present 80% of cases in family court are pro se, how will these people equally be able to go to Superior Court, where if all the rules are in place, who knows all of those rules? Or if one person does, is not the other pro se at a distinct disadvantage?
So when you appear pro se in front of the Superior Court, the judge is to give leeway to the understanding of the rules of evidence and the rules of procedure.
Leeway.
In making appropriate motions, they're going to have to guide them through that, and that's what they do now. If you come to court on a real estate transaction and you're a pro se person, you are not going to be held to the same requirements that a professional attorney is.
I'm encouraged that since one seems to be negative towards the leeway that judges in family court have, you would give that leeway to Superior Court judges too.
Because in Superior Court or the Supreme Court, these are courts where full constitutional rights are granted. Full due process must be held. In family court doesn't. I started off this, and I know it is damning. And it's maddening that this is the truth. But the truth is there is total lack of due process in family court. It is a court where that family court judge operates essentially at whim. You are totally subject to that person's discretion on how they want to deal with you, and your rights are, you may be granted some, you may not. It's, pays your nickel and takes your chance. It's not an acceptable way of doing business. It's unconstitutional. It's unlawful. And I hate saying that. I absolutely hate saying that. And I'm humbled by the fact of all the people that I've met and dealt with and raised these issues before me. I can't possibly represent the pain that they've felt going through this process. But the family court system, it's my understanding, and again, I'm operating on hearsay now. My understanding, it was set up because people show up in Superior Court and there's a trial of criminals, and the next case is a divorce case. So the divorce people are sitting in the docket next to the criminal docket people, and the judges, well, we want to separate these people out. We want a nice, convenient place for these domestic issues to be resolved. And in so doing, they dumb down all the rules and they dumb down the Constitution. And as a consequence, you're left with people that, I'm not saying that every family court judge is bad, but you have many of them that have unique, crazy crotchets. Everything goes to the woman. Everything goes to the man. Everything, there's alienation everywhere. There's all kinds of crazy things that are happening, and worst of all, and I didn't get to raise this, this is all superintended by Title 4D monies, and Title 4D has been corrupted to pay for this system, and that's not what it was designed for. It was not designed to force. It was designed for cases where a parent abandoned a family member. So the deadbeat dad, for those of you who remember back in the Clinton era, right? Guy skips town, lived in Iowa, he goes to Kentucky and is not paying his child support. That's what Title 4D was designed for. Well, the way Title 4D now forces the family court to operate, or it not forces, incentivizes the family court to operate, is a place where it induces the single family, single parenthood situation. And then that feeds on case after case after case where the parent who has been forced to not have access to their children keeps knocking at the door and keeps the case open. Protracted cases. That's the problem. And that's a pattern that you would discover if you asked these people to give their testimony and you collected it time after time. You would see that pattern is there. I have the testimony from Molly Olson, a New Hampshire legislator who, New Hampshire
now you're
minister.
testifying again. I'd asked you a question.
Okay.
Thank you for that.
Well, I'm answering.
Well,
the
you're good.
question.
You know, you're good at that. That's really, I'm taking a note here, brother. Any other questions for the representative? Representative George.
Thank you, Chairman. Thank you very much for to stand for families. And I believe what you say for everything. Myself, I'm really witness for this one because to call lie court, that would make me really feel. But like you say, is a constitutional code. How we can change that to become constitution, because to come constitutional, because it's to then to abolish. You can change. I know you are a change maker. You can change that to make that to look good.
So your proposal is to make the family court a constitutional court?
Yes.
Well, we'd have to pass laws that say that all these provisions that they have abandoned in the rules are illegal. And we'd have to say the family court shall comply with the full rules of equity, because divorce circumstances are cases in equity.
Representative Markell.
Thank you, Mr. Chairman. Sir, earlier you mentioned you saw problems with discovery. Did I hear that right?
Yes, that the people have that problem. If they're not allowed to present the case, they're not allowed to they ask the judge, well, we want to see this evidence from the opposing party, and it never shows up. It's never discussed. Yeah, discovery problem. That's a due process issue.
Okay.
Follow up.
Yes, if I may. Thank you. Okay, so are you aware of do you know what interrogatories are?
Yes, I do.
Okay, I'm sorry. Yeah.
Follow
okay.
up.
Sorry about that. Do you know what the limit of the number of interrogatories you're allowed to ask in family division are?
I do not know. I don't know the rules to that degree.
Okay. Do you know what follow-up?
Yeah, I'm turning you loose.
Would it surprise
Counselor.
you to find out you're allowed to ask 50 questions and have virtually unlimited requests for document production?
It wouldn't surprise me you're allowed to ask, but would it surprise you that none of those get looked at, or maybe 3 out of the 50 get looked at and 47 get dismissed as inappropriate or not worthy of discussion?
Well, do you know what the follow-up? Do you know what the standards for discovery are, sir?
Enlighten me, please.
Well, in other words, sir, you're allowed to ask for virtually anything that's relevant to the case that relates to a claim or a defense of a party, as long as it's not privileged. And
True.
Are you aware that some of the limitations that involved is when discovery crosses the line from oppressive and harassment to asking questions that are more focused and relevant? And by way of one more question?
One more.
Okay. Are you aware also that in the family division, you're also allowed to file motions to compel and motions to strike interrogatories if for some reason they bound on something that's inappropriate for the case?
I'm sure all that's true. I'm also sure that Rule 1.25 says the judge can say, that's nice, and move on.
Okay. And do you know how many, may I, one more?
I'm going to give you a 6-pack.
Okay, thanks. Okay, out of curiosity, how many interrogatory questions are you allowed to ask in Superior Court, sir?
I do not know. I don't practice in front of the Superior Court.
Okay, thanks. No further questions.
Seeing no further questions, thank you for your testimony.
I would just recommend Kat Heinrich as someone who's got some interesting data.
Chair recognizes Representative Susan DeRoy, co-sponsor of the bill. And we're now into our 3-minute segment rule, except for one person at the end who will be a rebuttal.
Thank you for allowing me to give some testimony today. My name is Susan DeRoy, and I'm from Stratford District 3, which is New Durham. I didn't think I would be here today, but when I ran for office, I had 4 people immediately contact me over the last couple of months about what's happening with their children, and I'm scared to death for them. Their stories are extremely alarming and very similar. Children are being placed in or allowed unsupervised visits with abusive parents. These children often return with bruises, burns, scrapes, and even worse. And many of these people are going to testify this today. One of the most troubling aspects that I hear is a recurring theme of punitive and biased treatment to the reporting parents. These parents are motivated and have a desire to protect their children. Frequently, they become targets of skepticism and hostility from biased magistrates and guardian ad litems. The negative response not only deters other parents from coming forward, but emboldens the abuser. Those who interpret the system's failure to act makes them think that their behavior is okay. Most importantly, this situation puts the children, let me say that again, the children at risk, forcing them to endure a cycle of abuse that has lifelong effects. And those lifelong effects keep coming back and keep coming back and keep coming back. And you know what that means? That means money. People are making money off of these children and off of these parents. We must reform our family court system to help these parents and their children regain their lives. No longer should cases drag on for 2 to 3 years, allowing abuse to continue and draining parents' savings on attorney fees and court fees, if they can afford them at all, and many can't. They can't defend themselves. This bill proposes closing the administrative court, as has been told, and transitioning these cases to judges who follow the law. And that's important. I'm not going to go over all of the benefits because you'll hear that coming forth.
You've got 30 seconds.
Okay, and I just pray that you all listen to these people and put yourself in their place and think to yourself, do I want my child to go through this? And do I want to go through this? Thank you.
Thank you. The chair recognizes Matt. Here we go. I'm going to try it. Saburin dit Chouanier. How'd I do? Oh, and I was so wanting to know how to pronounce that. Got a big stack of pink cards, and you're all going to get 3 minutes each. I would just remind you, you may not speak about a judge by name. However angry you are, however right you think you are, that is not allowed. Anybody who does that, your microphone will be immediately turned off and you'll be asked to leave. Chair recognizes Stephanie Turgeon.
Mr. Chairman, can I ask a procedural question?
Yeah.
Are there any rules about protecting the identity of children in testimony?
Yeah, and you cannot make, thank you. And don't mention children's names either. Thank you. Got to turn your mic on.
Thank you. Somebody asked a question earlier about what states have abolished the family court. Actually, I can send this to you guys' email. New York actually has, effective January 1st of this year. I'll send that to you all later. I stand before you today to give testimony in full support of House Bill 652 to abolish the family court in New Hampshire with deep conviction and a heavy heart. My experience with the family court has been traumatic, to say the least, and has at every turn violated my rights as a parent, my right to religious freedom, and my fundamental right to protect my child from harm. I'm here to tell you that the current family court system has completely failed my child, my family, and the public in every conceivable way. My son will turn 4 years old in June of this year, and we have been involved in the family court system since October 2021, when my son was 4 months old, where I am the respondent in that case, or in the case. Since day one, I've been fighting for my son's safety and well-being to be put first, for my right to raise him in accordance with my beliefs. However, the court has continuously dismissed my concerns, especially regarding the abuse my son has endured at the hands of his father. My son's father was arrested out of our apartment for domestic violence against both my son and me when my son was just 3 months old. He was later convicted by a jury of domestic violence against both my son and me. He was later convicted of criminally stalking me. This is not just an accusation, it is a matter of public record. To make matters worse, my son's father is an admitted opioid addict who has admittedly been in active addiction during points of my son's short life. The family court's response? Give my son's father 4.5 days a week of parenting time and give his protective parent, me, 2.5 days a week. Yep, you heard that right. No, there is quite literally nothing that the court has against me. I don't have a drug problem, never have, don't have any criminal history of any kind. Sounds shocking, but it's actually common in the family court because it's clearly not a real court. They don't care. After these incidents of domestic violence, my son's father snuck into my son's school and also became violent and threatening to the director. He then chose to have a 2-hour standoff with police, which resulted in him being criminally trespassed from the school altogether. Months later, my son's father threatened a nurse at the pediatrician and was criminally trespassed from there as well, which also led to the practice dropping my son as a patient altogether. Despite the fact that my son and I are adjudicated victims of domestic violence, the family court still requires, per their court orders, that my son's father and I share equal decision-making responsibility, including but not limited to scheduling all pediatrician or specialist doctor's visits in accordance with each of our schedules so that we both have the opportunity to attend. This does not protect me or my son as adjudicated victims of domestic violence and clearly disregards my safety. Despite my son's father's convictions in an adjudicated finding by DCYF involving lots of abuse, several black eyes, busted lips, and near broken nose.
Thank you for your testimony. We do have to keep it. There's a room full of people. The chair recognizes Anthony Kinney. Please come on up. We have a room full of people, and 3 minutes is fair to the other people.
Good morning, members of the committee.
Yes, sir.
For the record, I'm very skeptical about being here today as my family case.
Could you speak closer to the mic? Thank you.
For the record, I am very skeptical about being here today as my family case is still ongoing. I believe because I've already faced retaliation through the court that my being here today might affect the outcome of this case. I'm here today in support of HB 652. I've often heard said in discussion in this committee and as other committees about the family court, only parents that are on the losing side come forward to testify. That's not the case here today. My co-parent and I share equal custody. I'm not on the losing side. In May of 2020, my co-parent went to the family division with intent to take my parental rights away. The clerk informed her that she needed a lawyer for such action. My co-parent was then referred to an attorney who was not only a partner at the same law firm as the presiding judge, and he was a managed partner, her boss, but also had a deep personal professional ties with the judge, the family, his family, and the court clerk. Before our initial temporary hearing, while my co-parent was withholding visitation, I sought an ex parte order, which was denied. During the hearing, after my co-parent's attorney remarked, "Why are we here?" the ex parte was denied. The judge responded, "Yes, we had it denied." At the temporary hearing following the attorney's recommendations, the court stripped me of my decision-making rights, which were granted by God and protected by both the New Hampshire Constitution and the Constitution of the USA, granting my co-parent sole authority while also severely restricting my visitation, communication, and contact with my son. A GAL was appointed, who was also a longtime friend with the judge. What began as a low conflict case has now stretched nearly 5 years, escalating to a high conflict battle fueled by the court and its actors. The conflicts were created within the court. Upon discovering the relationship between the judge and the attorney, I requested the judge's recusal and was met with retaliation. After 4 years of battling this court's manufactured conflict, I finally regained equal rights and responsibility. Due to exposure and involvement with the Judicial Conduct Committee, the judge was ultimately forced to admit his bias, that he had not been fair and impartial, and he had to recuse himself. Violations of the Judicial Code of Conduct, as well as his own oath of office. During this time, my son endured repeated abuse at his mother's house, strangulations and attempted drowning, and other violent incidents at the hands of his older siblings. His mother resorted to physical punishment, including hitting him with wooden utensils and forcing him to ingest Dawn dish soap, as one of multiple punishments that morning before sending him to school.
15 seconds, sir.
Five separate DCYF investigations initiated by medical professionals and law enforcement documented these dangers, yet despite presenting clear evidence of my ex parte was denied, the court refused to put any evidence on the record.
Do you have any questions for the witness? I have one. I think I heard you mention a judge was disciplined by the Judicial Conduct Commission. That's good to know. I mean, not that they had to be, but it's good to know that it can be. Committee. Okay, sorry. Thank you, sir. Chair recognizes Randall Collier. Got to push the button. Bingo.
Good afternoon, Chair, Committee. I'm for this bill to abolish family court. Title 42 is a non-positive law title, which means that there isn't actually real evidence that goes on in family court. When you look up New Hampshire executive branch agencies and you go down to the letter F, it says family mediators, chapter 328. That's exactly what they are, family mediators. They're not supposed to do constitutional issues. They're supposed to be independent third parties. If you look into administrative law, circuit court, family division, there's all three branches of government in one, where the executive branch runs the show using judicial branch documents. U.S. Supreme Court Justice Gorsuch said that American administrative law judges are not judges and these are not courts. The reason why it needs to be abolished because there was talk about rules of evidence and motions. I filed 3 motions for discovery, 2 for show cause, along with 500 other motions, all denied. So when it said rules of evidence don't apply, but it's the preponderance of the evidence, this is direct washing machine child abuse from the court. You can't have preponderance of the evidence if rules of evidence don't apply. It's an oxymoronic statement. Yeah, let's abolish family court so we don't hurt any more innocent kids. I did 2 parenting appeals to Supreme Court, a motion, a writ of certiorari to Supreme Court, all 3 denied. 2 district courts and a U.S. Court of Appeals all denied. 12 years protective order, no evidence. This is the definition of child abuse through all branches of government. And it's in the American jurisprudence. So if anybody has a question, you can read it. It's all 3 branches of government in one. So it's not very cool to military veterans. We don't take highly to treason and child abuse.
Thank you. Chair recognizes Aubrey Friedman, who now gets to testify because I got the hearing right.
Mr. Chairman, committee members, I speak, Aubrey Friedman, I live in Bridgewater. I speak in support of this bill. The family court is a rogue division of the government, and it's clearly, I mean, there could be an isolated case here of abuse or what, but there's it carries a history of abuse and tyranny. And so I don't think it can be reformed, to be honest. And they clearly don't follow due process. And also this business of not swearing in, isn't that a red flag right there? Not swearing in, even when you do testimony for the online bills or whatever, you're like it's you're kind of like perjury thing, not swearing in a court. So that's a red flag. It can't be reformed. I like the idea of the mediation court or mediation office, family mediation office, try to work things out voluntarily, and maybe that can bring some of the volume down. I mean, naturally, it's going to be adversarial with family divorce and, problems like that. But doing it voluntarily can maybe bring the volume down. And then if they can't work it out, then it goes to Superior Court, and they have to follow due process and the Constitution. And also, I just want to mention that the taxpayers are evidently going to be on the hook for a lot of this abuse and corruption that has happened. And so if we go to a system that works better, like the mediation and the Superior Court, that will, I think the taxpayers are going to have to pay a ton of money, but maybe in the future end some of this abuse and trying to rectify it through claims and so forth. So those are the reasons that I support the bill. Thank you.
Thank you. Well spoken. We have a mediator thing now where people can go and try to work it out. And it only goes to court when that doesn't work or they don't want to do it.
Well, something isn't working right now, because otherwise, why are we having all these horror stories, basically?
Well, I don't know about that, but I do know there's a lot of cases now, and that's because the divorce rate's about 50%. But we do have a mediator program going on before they get to family court.
Are people advised of this? You can do this first? I'm wondering.
Why, we have somebody who actually knows. Other than me, I don't know.
So would you believe that my daughter is going through a divorce and for a year has been involved in mediation and it's still ongoing? So I'm not sure how this bill is going to help speed up any processes, because she has been with mediation, which is very costly to her. And when he doesn't want to agree to something, then it becomes more costly to her. So I'm not quite sure how and she sees no end in sight, right? They just schedule another mediation appointment 4 months down the road. So I don't see how this by having everyone go through mediation would speed up the process.
Well, it would be voluntary. So I think that's the key thing. If they choose to do it, and maybe, I don't know how many would, or advise, maybe it's a better idea, but it could help.
Follow up, Mr. Chair?
Follow up.
So this was ordered by the court. She didn't voluntarily go. This mediation was ordered by the court for her.
Under this bill, it is voluntary. So if they don't agree to it, then it goes right to the Superior Court, and they have to follow due process. I think that's the difference here.
And if they have to follow everything exactly as it's listed, I've read the Rules of Evidence book 5 times. And if they have to follow various things, I've read it 5 times, and I'm not sure I could do it. So I'm just wondering, what does this do in Superior Court? You have to hire an expensive lawyer. I'm just trying to get my hand around this here.
Well, following due process, I think giving everybody a chance to present it, so each side feels like they got a fair shot. I think that's the difference here, and following the Constitution.
Okay. Any other questions? Thank you.
Thank you.
Katrina Heinrich. Oh, and she has handouts. We like handouts. If there's only one of each, they go to the clerk of the committee for filing.
Thank
You didn't, I like how you kept that going right along. Thank you.
Thank you. This is the one.
We have had a history of people forgetting to pass things. Okay, Ms. Heinrich, while they're passing this around, welcome to Children and Family Law Committee.
Thank you. Thank you for having me again.
Welcome.
I'm Katrina Heinrich, and I was asked by the bill sponsor to provide some data for you guys to look at, which is on its way around. And some of it is critical in the way that those of us that's been working on this for quite a long time have been using a methodology that's very similar to the DOJ. It has to have three verifiable things. It has to be detectable, has to be verifiable, and it has to be quantifiable. So for our application, if there's a pattern, there's a pattern. And then you guys can go ahead and educate yourself on the little blib they have for the rest of it. The next sheet is actually a graph I put together for you. And this is case profile samplings. This is, I can't even tell you how many cases we went through on this, to form these patterns, to discover what exactly is going on and comparing it to what they're saying, which is often, and you guys know this, it's very emotional for them. But we needed to put it into a data. We needed to find a way to do that. So we had to find words that made sense. And this is the chart that you've got. If you'll notice at the end of the chart, there's a little key that says NA equals does not apply, kind of common one. But it was much easier on this chart to put in the 3 things that didn't apply than fill in the whole chart with X's. And what this is at the top is those A through G are actual cases. Those are the years of the cases, so it's a huge sampling. It's different courts, another sampling, and yet we found the same patterns being reported in these cases, always resulting in the child being abused, a parent being abused, or both parents even being abused. So this chart really gives you kind of insight into the layers of it. The theme of this is that the family court was unsustainable in about 2007. They started realizing they did not have enough families in need to support under Title IV. So there was an upswing, shall we say, in looking for cases in higher income families. And I believe that Representative Bernardi handed you one of those people who is a judge. And targeting started there. Now, with that said, I did comparison with the state of Minnesota. Minnesota found the exact same upswing at the exact same time. And the swing has never stopped. It's continued. So
20
chart,
seconds.
Yeah, this chart gives you that. And the last page, because we keep talking a lot about how these cases are, shall we say, artificially created, and they have a lot of high conflict. When we hear about it, we hear about high conflict as in there's something wrong. But in this particular case, this is from Cohen and Winter, and they were looking at HB 185 for the parental rights.
Yeah.
And they responded to it in their own blog. And you'll look at the bottom yellow, you guys.
We're going to take a look at that. Will you accept any questions? Any questions? Questions? Thank you for your testimony.
Excuse me, Mr. Chairman. Could I just request, I don't know what's going on, but there's just never enough copies to reach me.
Well, sometimes they don't reach me either. It just does a disservice to the person testifying if there are not enough copies for the people in the room. So it doesn't help their case, basically. It's their problem to solve.
Mr. Chairman. I think maybe not everyone is aware that we need one copy for the file, so maybe that's why you're getting short. Okay.
The chair recognizes Drew Cullen for 3 minutes. Not seeing a Drew Cullens. Chair recognizes Frank. He took a shortcut. He was going over that way. Yes, sir. Yeah. Got to push the button. Got it.
There we go.
Good.
Hi, I'm Drew Cullen. I support 652. I've been a litigant in family law for nearly 8 years and have 30% parenting time. I pay around $800 a month. I underscore that I have no criminal history. I'm a veteran, business owner, homeowner, elected town official, UNH alum, father, in sum, a normal guy. No different from many of the litigants and people you hear today. My case has hundreds of filings to include 2 Supreme Court appeals, one of which dealt with the 8th Circuit in Keene, stealing my parental rights on vaccinations and basic religious rights to exempt my 8-year-old from being abused with the COVID-19 jab, and thus overriding laws that you yourselves wrote. It's case 2022-0445. Go read it. You can read my entire case in the trial court as well. I'll even give you permission to see the sealed stuff if we have judicial oversight. The New Hampshire Supreme Court upheld this blatant abuse of my basic rights and my daughter's health and safety. Making law from the bench and denying basic rights is an anathema to our way of life. We petition our grievances to this body year after year, decade after decade, so that this body will rein in the lawlessness in the judiciary, which, as history has shown, is the most corrupt branch in the New Hampshire government. And the few bills you manage to pass are watered down and toothless. Our civil rights are being violated in family law. Our kids are being kidnapped and abused. Our money unjustly stolen. We are denied juries and the presumption of innocence and equality before the law. And that is why family law must be abolished. This legislature must end the human trafficking which occurs every day in family law and restore liberty to the free peoples of New Hampshire. If you have any questions, I'm happy to answer.
Well stated. Thank you. Kang Lu, chair recognizes.
Good afternoon, sir. Thank you for recognizing me for 3 minutes. To begin, I'd like to say that the word court is used improperly. These so-called family courts are not courts. That's Title 42 U.S.C. 666. They are administrative, like expedited administrative and judicial procedure. That is an Article 2 procedure. It is not a court of law. It is for the adjudication of a public entitlement, either of child support from the state or of foster care managed by the state. It has nothing to do with private rights. That is why they are not courts of law under Article 3. Next, I want to say that the persons who are involved in those courts, so-called courts, are incentivized by, quote, incentive payments computed as a percentage of child support collections. That's 45 FCR 304.12. That is essentially an illegal act conducted by an officer because they are being they're being corruptly influenced to give one side of the family more parenting time in order to obtain a greater child support ruling, which will benefit the state's agency. But the persons who are doing this, you're right, they're not necessarily JDs, but I'll tell you something else. They are not, in fact, acting in their behalf as judicial officers, because that would be a violation of separation of powers doctrine. They're not acting as judicial officers, and even if they are a judicial officer, what they are acting under is a interdepartmental service agreement between them and the agency of the state responsible for collecting the money under Title 4D or Title 4. Which brings me to the other point is that subchapter 4 is entitled Grants to States for Aid and Services to Needy Families with Children and for Child Welfare Services, meaning that it should not be applied to normal people who have otherwise functional families and who are otherwise financially solvent. It is this misapplication of the law that is the most concerning to me, because the law is actually written quite well. It allows the state to take care of the most needy and most vulnerable members of society.
15 seconds.
However, it has been corrupted to be applied to everyone, which means that it is used to profit those who are in charge of administrating those things.
Thank you for your testimony. Could you print that out? I mean, I don't think...
I will send you an email. Give me about 24 hours.
Sure enough. I mean, there's some good stuff in there I want to check out.
It's the truth.
Well, that's maybe, if it's the truth, that's good stuff.
And the people are not told this, so they feel like the quote-unquote judge is doing them wrong. But in fact...
Would you take some questions?
Yes.
Because your time is up, I'm afraid. Any questions? Nope. Thank you. I'm looking forward to that. Chair recognizes J.P. Nadeau. And you know what I did when I testified before a committee the other day? I didn't put the button on either. It's on, well, the red light will tell you. You just hit something, and if it goes red, you did it. There it is.
Okay. Good afternoon. Thank you for letting me speak. I'm speaking to you as an attorney with 50 years of experience, both as a trial and the marital matters. I'm speaking to you as an attorney with 50 years of experience. I have been a trial attorney in marital matters. In the early 70s, I served as a marital master, which had similar powers as your family court judges now, where they just hear things, then they issue an order or make a recommendation. I've served as a marital mediator and as a GAL.
Take your time, sir.
But I'm speaking to you as a grandfather. I'm sorry. Give me 1 minute.
Sure enough, sir. Would you like to go back and we can call you up again?
I always have this. I'll get over it. I support this bill wholeheartedly. It really is, family division should be abolished. And there should be this family, Office of Family Mediation with professional mediators, psychiatrists or psychologists. I know mediation doesn't work, as somewhat here, but you really need professionals. The family division, for example, I've had experience in this over the past 4 years. They'll have 30-minute hearings on offers of proof with multiple motions at the same time. That gives each side 15 minutes to make a presentation to the court. There's no checks or balances because you don't know what the other side may say to counteract it. You can have clients or people making, with a narcissistic personality, wanting absolute control over the children, will do anything to get it and say anything to get it. If a judge does not like you in the first instance to some extent, or has some type of attitude towards you, you can't change it. And a big problem in the family division is if you're on the wrong side for any reason, attitude or whatever, the judge will pontificate in its orders. And I mean pontificate, so that if you wanted to challenge it, if you wanted to go further on, whether it's the Supreme Court or whatever in instances, they justify it in there. There is, I'm trying to, well, there's discussion, for example, of interrogatories in discovery and the 50 interrogatories to submit. Well, if a judge says favors one side and that side submitted 156 in subparts, the judge said, well, that doesn't count the subparts. If this Rule 125 required disclosures, if the other side wants to play games with the discovery, they'll say, he didn't provide this, or she didn't provide this one item, and the judge will say, you can't do discovery. You can't take depositions until you comply with 125. But that's a single individual making a judgment call. And as I say to you, if there's an attitude against you, it really protracts. One gentleman said protracted divorces creates more conflict.
You
more-
got about 20 seconds, sir.
I'm done.
I owe
guess,
you
really.
then.
No, I'm done.
Okay, thank you. Any questions for counsel? Seeing none, thank you, sir.
Thank you.
Chair recognizes Chris Burno. Do I have it right?
Burns.
The name?
Burns.
Oh, like you wrote.
Unless there's somebody
Okay.
else.
Like you wrote.
Thank you. I come here today to give you a bit of a perspective from someone who has practiced law in New Hampshire.
A little
for-
closer to the mic, sir, for the ancient of years.
For 23 years, I've been practicing law in New Hampshire. So I give you the perspective of an attorney's view here. As you probably know, there are 3 levels in the court system here, Supreme Court being the highest. Intermediate is your appellate county courts, the Superior Court. And your entry level is your circuit court, comprised of the probate, family court, and district division. Now, for reasons I still haven't figured out after 23 years of practice, the technical rules of evidence don't apply in family cases. I still don't get it. I get the theory behind it is you don't want children placed on technicalities. But the reality is there is somebody, a gatekeeper, the judge, who's going to tell you what you can let in and what you cannot let in. And under the current system, it has to be material and relevant. And you get a ton of evidence based on emotion. And you're getting decisions based on emotion because nobody is explaining you can't let exhibits in that have no probative value. And that should be explained to them, and it's not. In addition to the lack of evidential rules, there is almost no appellate oversight here. In certain cases, there was a time where you could take an appeal, a de novo appeal, from the family court to Superior Court, specifically abuse and neglect cases. But some years ago, that avenue was eliminated. Now your vast majority, almost exclusively appeals from the family division go to the Supreme Court, straight to the Supreme Court. And the odds of the Supreme Court taking your run-of-the-mill disagreement in a marital case is almost non-existent. Unless there's a new statute that needs to be interpreted, and everybody needs that view from the Supreme Court, it's almost always you're going to get a form letter from the Superior Court that's the Supreme Court rather, that says the best court in the position to determine the credibility of witnesses and evaluate evidence is the trial court. So we're not going to disturb their findings. So compare that to the federal scheme, which essentially says all of your federal rights come in different shapes and sizes. They're not all equally important. Your fundamental rights are your most important. Parenting rights are in that group. So they're subject to the strictest scrutiny. And the current system, I see she's showing you the, watch this. I'm about to get the hook, I feel. All right.
Strike that, half a minute.
So the U.S. Supreme Court has determined in the case of Troxville that parents are deemed to be fit parents unless the state has proven otherwise. And what you currently have in abuse and neglect cases coming forward is you can have a non-accused parent who wants to get their child back, but under the current statutory scheme, they actually have to file a request, and the court will schedule a parental fitness hearing for that parent who's non-accused by the state to try to prove to the family judge that they are adequate to take their child back when they're not facing any charges.
Any questions for counsel? Just a couple of statements. I am working with, and I'm going to blank it out, but I think it's the New Hampshire Bar Association is working with me to produce an intro book for people who are going pro se. And I've been talking with their executive director to see what can we put in it, because there are materials, but I'm not quite sure many people are knowing about that, much less getting them. But that will speak to the issue of why did they do that and what do I do next, and if this, then what? Doesn't solve every problem, but it will solve maybe a few. And you might also be interested to know that I've been given the authority to make a subcommittee out of this committee. We'll probably stand it up April or May to pick up the good work that was started in the Special Committee on the Family Division of Circuit Court. Yeah, we were putting Band-Aids, and you know what? It did some good job. Did good job doing good work. I think we're going to do some more. So thank you for that, and seeing nothing more. Appreciate, Counselor. Chair recognizes Brooke Lowe Farmer.
Hello, this is quite intimidating, I'll be honest. When I was asked to come by the representative, I said I was very apprehensive to come and share my story, as another father mentioned my case is currently ongoing and has been ongoing for 3 years. So I guess I'll just tell you part of my story because it echoes a lot that's already been said. So I'll try and be quick for you, Chairman.
2.5 minutes, so let her roll.
All right.
Okay.
My case is out of the 9th District Family Division. The judge has presided over my family case since the beginning in September of 2021. The judge's rulings over this case demonstrate clear bias against women, veterans, and law enforcement. This is my personal experience. In one proceeding, the judge would cut me off and not even let me speak. In another, it was my parenting plan that was being discussed. I was employed as a police dispatcher after extensive background checks, polygraph. My ex-boyfriend, the father of my child, and his counsel ultimately got me fired from my position due to slander, subpoenas to my employer, the police department, sending private investigators to harass me while I was at work and to my home. The judge remarked in his ruling that it is an unfit employment for a mother to work for a police department. The judge has allowed the father of my child to weaponize the family court system to keep me in constant litigation with no means to afford an attorney. The father's attorney herself defending the father, who is a domestic violence abuser, while she sits on the board for Bridges, a domestic violence shelter. All of our exchanges take place at a PD, a police department, and I wear a body camera. That cost me $7,000 with a lawyer to get that one change done in 3 years. That is the only thing I've gotten in my favor. $7,000. Throughout all of these proceedings, the father has testified falsely and nothing's ever done about it. The judge has misapprehended abundance of information presented throughout these proceedings, including falsely stating, I testified under oath that the child would be adversely impacted by spending more time with me, the mother. I have audio recordings of all of my hearings. Nothing remotely close was said. In family court, if you can afford an excellent attorney, it seems allow perjury, as with the case of my recent trial. The father of my child made completely false statements that I easily disproved by my testimony and evidence I presented. The judge never addressed that either. In his ruling, he said, the petitioner oftentimes seemed unable to answer questions or confused.
You have 20 seconds.
But seemed truthful.
That's the 20. You done?
No, I have so much more.
I'll give you 20 seconds. You're on a roll.
Thank you. I guess why I'm here is his last ruling, this judge, like we heard for so many others, is made a biased decision that being in law enforcement for a woman and a mother was not okay. He essentially ruled that the father would get the child. His last ruling removed a 3-year-old little girl from her mother, her 3 siblings, to go live with her single alcoholic father, whom had not spent any significant time with her until she was 2.5 years old.
Will you take any questions? Okay, thank you. Thank you. You came here kind of trembling. You did a great job. You really did. Us?
Yeah.
Us? Are we intimidating?
No, I
I don't think so.
intimidated, though, when
No,
I
anybody?
when I sit there, I'm
So much to say because as we were asking questions about the interrogators, sir, I had asked, and I've never received them. There's room for me, but not me. And I'm so sad.
Thank you. Chair recognizes Alice Giordano. You get 3 minutes. No, we control that. This isn't Congress.
Push my little button here then.
And here you go.
My name is Alice Giordano, and I am testifying in support of House Bill 652. I am a national news reporter, and in my 30-year career, I have never come across anything so corrupt as the New Hampshire family courts. It is a system that is not riddled with honest mistakes, but rather comprised of abhorrent people with a deliberate fetish for making lawless decisions, impoverishing parents, willfully traumatizing children, and putting them in danger, all to carry out personal agendas and line the pockets of a cottage industry comprised of greedy club members and gatekeepers. I should know I am one of its victims. I lost everything to this mafia-like ring, and while my daughter, now college-bound, was and remains an overachiever, she is scarred for life by the reckless actions of this nefarious clique. Instead of seeing to it that a troubled man gets the counseling he needs in order to ever be safe around his daughter, this anarchy used him as a pawn in a battle it deliberately incites to keep the profits flowing to its cronies. The court's twisted crusade to gaslight a parent and engage them in an ultimate battle for their children's life is like a family court version of Hunger Games. In my case, it tried to force me to hand my daughter over to a man, a self-admitted transient who never spent so much as a day as his daughter's parent, didn't even know how to spell her name in court pleadings, and called her dead weight. A man who told a Massachusetts parole board that he understood where his brother was coming from when he explained he executed his girlfriend as she lay sleeping with their newborn baby because, quote, he didn't want the responsibility of a family. A deadbeat father, abetted by the New Hampshire Family Court in his open vow to never spend a dime to support his daughter. When my daughter was 5, I asked him to show some interest in her, so he showed up at her school, grabbed her, and smashed her face against the sidewalk, and then left the country. I had over 37 sworn witness statements and other evidence detailing this terror, but the court, in its chronic quest to keep evidence off the record, rejected at least 5 separate motions requesting something so basic as an evidentiary hearing. A New Hampshire family court judge wrote, I thought about granting Ms. Giordano's request, but then decided, why bother since I already knew what I would decide. Another judge openly wrote, he wasn't interested in evidence, and the court's so-called child advocate told an attorney, abuse doesn't matter, only what the court wants. But the senseless and indefensible actions didn't stop there. In a move many of us ascribed as shocking the conscience, this judge, one of the judges, since I can't mention them, issued a secret kidnapping order of my 12-year-old daughter, writing the father shall obtain the
15
minor
seconds.
without the mother's knowledge. This unrestrained directive was to award an adolescent girl to the same man who told the court that he sometimes pays cash to sleep in a basement in Washington, D.C., and spends the rest of his time in Singapore and Bangkok, sex trafficking epicenters of this world.
Thank you for your testimony. Do you have written testimony? You are finished, ma'am. The others managed to abide by the rules. You are hurting your cause by behaving this way. Chair recognizes Frank Kurland.
Good afternoon, Chair and committee members. I support this bill. Today, 50% of the U.S. marriages end in divorce. With that being said, divorce is more than a $60 billion industry. When it comes to divorce, money does the talking. Most people cannot afford a divorce as a whole. The family court system is nothing more than a business plan. It's a money-making business. The average cost of a marriage license in the U.S. costs about $30 to $70 on what a state couple is residing in. The cost of divorce is an average of about $27K to $57K, and that's yearly, depending on how much money a person does or does not have. If a divorce case goes on for 4 years, that can cost over $108,000. If a marriage license is so cheap, why does a divorce cost so much? In any civil courtroom, you have the right to an attorney, and the jury decides the verdict. However, in family courtroom, the judge is the dominant one, the decision maker. The Constitution of the United States does not apply in family court. A person does not have the right to an attorney, and there is no jury. When it comes to divorce with children involved, the best interest for the child is equality between both parents. That means 50-50. The court system is not a friendly environment and does not work with equality. Seeing it with my own eyes, attorneys encourage their clients to be aggressive as possible, often encouraging their client to make accused accusations. Of course, if someone is getting accused of something that they didn't do, they're going to fight against it. More fighting means more time in court, more money spent, and if a person does not fight, they can lose everything, and that includes his or her children. The federal government provides incentives to states for family court services through Title IV-D of the Social Security Act. These incentives include reimbursement. The federal government reimburses states for 66% of eligible child support establishment, modification, and enforcement costs. Incentive payments. States receive incentive payments based on their cost effectiveness and collections. Matching grants. States receive federal matching grants for child support enforcement. How it works. States submit a federally approved state plan for the federal government. States designate a child support agency prepare the state plan and enter it into agreement with the federal government. States receive federal reimbursement for eligible costs. States receive incentive payments based on their cost effectiveness and collections. And yes, the courts do discriminate against veterans. I thank you for your time.
And thank you, sir, for being concise and brief and on point. Thank you. Chair recognizes Dana Albrecht.
Thank you, Mr. Chair and members of the committee. My name is Dana Albrecht. I think you've heard a lot of the problems with the court from other people. I would just add to that, February 4th on House Bill 350, you also heard a problem wherein the former chief judge of the administrator court, who cannot be named, committed perjury in his August 26, 2022 deposition with intent to submit falsified, sign off on falsified transcripts for appeal. That being said, I'd sum up what I heard earlier is that our magistrates and officers of government are not accountable to the people at all times. And rather than that, we have this family court that constitute the private interest or emolument of any one man, family, or class of men. Public liberty is manifestly endangered. Thankfully, we have this bill as an effectual means of redress. Please pass this bill. The trouble, though, is wealthy men are sometimes difficult to convince, as we've heard for 2,000 years, when the rich man was unkind to Lazarus. You've heard many Pharisees, teachers of the law, public officials come before you, telling you what a good job they're doing, trying to justify themselves. I didn't hear them say they fast twice a week, but same difference. And you've heard a grandfather here beg for mercy. You've heard so many families here, and maybe we didn't do everything right in our family life, but we're begging you for mercy. Ask yourselves, who is justified in this situation? Please pass this bill. Thank you.
And thank you. You come here quite often and are eloquent, sir. Thank you.
Thank you.
Chair recognizes Drew Cullen. Chair recognizes Teresa Bastosh. Almost. Oh, there is. Okay. Yeah. I mean, you've been writing it a lot longer than I've been reading it, so yeah. Yeah, I think you got it.
My name is Therese Bastarash. Thank you for the time today. I've gone through divorce. I can sympathize with what your daughter has gone through. I'm also a mom who adopted my 2 sons out of DCYF custody. In total, I have about 10 cases in the basement, probably about 7 years in family court. The one thing I want everyone to hear today is that it is a racket. It is not in the best interest of the children. It is not in the best interest of the families. Right now, for every dollar collected for child support, the state gets $5.12 back from the federal government. It's money driven. It's not constitutional. If you think about it, what is the most corporal punishment thing you could do to an individual? You could throw them in jail for life. You could put them life to prison. But I would say taking someone's child is right up there. And we're doing that without constitutional, what our forefathers put in place. We don't have a jury. We have a judge who will decide whatever the heck he wants to do. And I know I only have 3 minutes, so I'm going to go as quick as I can. The most crazy, most recent was my 10-year-old, who I have permanent guardianship over. His grandfather came out of left field. He had been told by DCYF he was not allowed to see this child because of evidence of sexual assault on this child. He came out of left field and asked for grandfather visitation rights. Very clearly defined, the RSA, what he's allowed to do. Went in front of the judge. The judge decided to give him a parenting plan, that I was to give him his medical records, his school records, an update every week as to all of his activities, and unsupervised visits, including Christmas Day for 8 hours. This child had not seen this man in 6 years. The other judges that came after, and that's the one thing, every time you go to a hearing, it's a different judge. So you have to start over, and you're re-victimizing, you're wearing people out, hundreds of thousands of dollars in law, losing your home. When I should be there for those boys and helping them as a mom, as a Mimi, no, I'm pulled out of work to go to court every time I turn around. That's not efficient. These cases should be over and done with within a month. But they drag on for years and hundreds of thousands of dollars at the detriment of those parents being able to be healthy for those children. But this judge, he ordered a parenting plan. The following judge, I said, is this a grandfather's visitation or is this a parenting plan? Because I'm not going to be the one to set a precedent. And if I'm in contempt of court, you can haul me off to jail. But I'm not doing this. We're not doing it. And Christmas was coming. I prayed. I fasted. And you know what happened? Out of nowhere, this 10-year-old decided to confide in a school teacher with how he had been sexually assaulted by this grandfather. We knew something had happened, but he wasn't willing to talk about it when he was 5 and 6 years old. That teacher, Mandarin reporter, reported it. Investigation happened. The police talked to the grandfather. He dropped all of the requests through the family court. That was our saving grace to protect that child. That judge was legislating from the bench, and we had no recourse. None.
Thank you for your testimony. That's a compelling story you have. Does anybody have any questions for the witness? Representative
Thank you.
Molly.
Can you explain the $1 child support to $5 back?
Sure. So as you have to go, so say you have a deadbeat dad or you have someone who's not, and they're taking it from the paychecks, it's going through DHS to get to the mom or get to whoever's been ordered the child support. For every dollar that goes through that system, there's a total of $5.12 in incentives that come from the federal government back to the state. So there's money driven to drag this out to not have 50-50 custody.
I don't distrust that for a minute.
I can get it too.
Thank you.
Yep,
I'd like
I'll
to
get
have
that.
it in my hand.
Mhm.
Yeah, thank you.
Yep, it's corrupting the whole situation.
Thank you for your testimony. Chair recognizes Robert Tangway, who has 3 minutes and 47 seconds. You're really building it up there, my friend.
The power of compound interest. I will allow someone else to make my introduction.
Concord Police Emergency. Hi, I'm on Region 196. I'm still calling on the line located at number 2 Pillsbury Street, Suite 300 in Concord.
I don't think we can hear it.
This is the Bar Association. So what we're hearing is a police call from the Bar Association where I went to go get help. And they called the police on me, and it's documented. But
it's an individual that they've identified that they don't want to do business with, but he was
an
kind of
individual they
delayed
don't
there
want to do
before he
business
left.
with, a pro se litigant.
Yep, that's all accurate. Okay, what's the business?
The business is the New Hampshire Bar Association.
New Hampshire Bar
Okay.
Association.
And who is this person?
His name is Robert Tangway, T-A-N-G-U-A-Y.
N-G-U-A-Y, that's me.
Okay.
And they're going to say they're afraid of
Okay,
me.
so it's do you want to trespass him?
Well, we don't know that he's left the building. We just want to make sure he's safe for people.
Okay, so they don't know
Sorry,
I've
one
left
more
the
time.
building.
You're not sure if he's left the building, and then what?
We don't know that he's left the building, and we want to make sure it's safe for our people.
Safe for our people.
Okay, can you elaborate on why it wouldn't be safe?
Why wouldn't it be safe?
Well,
Robert
he's
Tangway.
had repeated contacts with our office, and his name and picture are posted on a bulletin board of people.
His
that
name
don't want.
and picture are posted on a bulletin board. Robert Tangway. Haven't seen my kid in over 2 years. No arrests. Nothing. Some of you people have not even I guess except for the state trying to arrest me. And I've been before this general court many times, and also did the same tactic that the Domestic Violence Coalition. So I oppose this bill, and I ask that I get a couple extra minutes. If not, I do request that you guys do ask me questions, because I'm a wealth of knowledge. I've read the family courts. I've read all the statutes, including 546A:5, which requires the judge to shall consider assets in determining child support. Now, the system that we have in New Hampshire, this bill won't pass. We need to repeal 173B, which is domestic violence, which is being used to weaponize at the benefit of lawyers and federal grant money the courts. Fictitious domestic violence petitions. I have also video that I can send to you for the latest court hearing, because I record all the court hearings with permission, where the judge, after having the defendant laugh, said that the police tell people to go to court to get a restraining order. So when you look at the hierarchy of evidence, probable cause is what's required for a police officer to apply for a warrant. Preponderance of the evidence, which is higher standard, is required for a domestic violence petition. So what we have is really a racket of lawyers, lawyers who are making money and advocating laws, including the Domestic Violence Coalition, which has spent over $10,000 last year in advocating for laws. And it's all in public record. So I know you guys can't rehear my case, and we really have a problem with the Supreme Court. So we're going to the people who are not able to help. Judges write lies. That's why we need a jury. We could just simply repeal this, or repeal the family courts, and then it would go back to the way it was before. We wouldn't have to do anything. But I think we also need to repeal, if we really want to get the change, and people, because these people haven't been heard. I haven't been heard. That's the problem. And if
Mr.
you-
Tangway, I think we're going to cut you off here because of time, but you said you would answer a couple questions. I hope briefly. Does anybody have a couple of questions?
On suggestions I have to make the bill better might help you.
I will give you 1 more minute because you're one of my frequent flyers.
Thank you, sir. Okay, so we need a jury, mandatory. That is not a waivable right unless it is told to someone. So when we waive rights or waive rules, that needs to be like, you should be allowed to object to it. So we need a jury. We need to repeal 173B. It's unconstitutional. The police are supposed to make an arrest. And then we also need to repeal judicial sovereign immunity, which is unconstitutional anyways, Article 8. The state of New Hampshire, you guys need to read your constitutions and base laws upon this. I suggest that this committee does go forward with this bill, but examines it in maybe a subcommittee to finally resolve this issue because it's hurting our children. It's that simple.
Thank you, sir. Appreciate much.
Any questions?
No.
Thank you. I'll send you other materials.
Appreciate
God
that.
bless.
Chair represents former State Representative Leah Cushman for 3 minutes.
Thank you, Mr. Chairman and members of the committee. Leah Cushman, Ware, New Hampshire, New Hampshire Family Justice. If the legislature creates a court of law or a court of equity and then puts it into statute that the court is not bound by rules of equity or common law, then the court is not a court of equity or a court of law. Then what kind of court is it? It's like calling something a bathtub, but it's convex and made of paper. Okay, so what kind of court is it actually? I think the ambiguity is part of the game. I think it's works in favor of the system, of the business model. It keeps people confused and not knowing how to resolve the issues that they see. If you don't know the rules, you're at a disadvantage, and the court has all the advantage for whatever outcome it wants. If you want to come back, if they want you to come back, they create or encourage more conflict. They'll bring in outside parties who also benefit from grant money that's flowing in from the federal government from these cases, and they create conditions for your case to be protracted. And herein lies the rub. When you are in this court, there is no due process, and if there's no due process, then you don't have Miranda rights, right? There's a preponderance of the evidence, and if there's a suspicion that someone is abusing a child, then they've already incriminated themselves in family court, and there's supposed to be immunity for things that go on in family court, but we see that that's not applied. So it's just more mixing up of proper process of law. It just poisons the entire well and the ability to make sure that justice is had. And when they go to a court of law, they can say, you know, my Miranda rights are violated, and then you can't stick the charges on this person. So the question about the mediation, about what the difference is, current mediators are private contractors, and this bill proposes a state budget funded certified family mediators. They're employees of the state. So then there's no, if it's funded just by the state budget, and I say that for the entire court and the mediation that's being proposed, then there's no opportunity for federal funds like we've seen with USAID money and other federal programs that are incentivizing and being abused with fraud all over the country. It's just the same thing going on with the family court here. There's no possibility for that if you're just running the courts off of a state budget without federal incentives that drive people who are involved in the court to seek certain outcomes for financial gain. So remove those incentives, remove the ability for judges to use broad judicial discretion. That's antithetical to American jurisprudence anyway. If you read maxims of law, judicial discretion is supposed to be very limited. Right now, they already have to hire expensive lawyers. And because cases are often protracted, and because attorneys, 90% of litigation in New Hampshire is through family court, and because they know that the judges have broad judicial discretion, the lawyers are often not willing to go to bat for their clients because it would be career suicide.
You got about 10 seconds.
They go through 3, 6, 9 attorneys over the years. What's happening with DOJ right now? They're going to dig into these HHS programs, and they're going to find the fraud and waste and abuse in the family court systems across the country. It's being called to be dissolved across the nation. New Hampshire needs to get out of the way before this windfall hits.
Thank you. Will you take questions? We have none. Thank you for coming. Chair recognizes Aaron Cregan.
Good afternoon, Mr. Chairman, members of the committee. My name is Erin Cregan. I'm the general counsel for the court system, including the family division. Representative Love, to check you by name, I think you made an observation to me the other day that confidence in the family division was at an all-time low. I'm worried that that isn't true. There's actually a long history that I completely understand in New Hampshire, that we cherish our freedom, and bringing the matters of your personal life into court is so difficult. Having the court make decisions about time with your children, whether you'll continue to live in your house, whether you will continue to be married to someone you maybe don't want to be divorced from, is so difficult. I think it's difficult everywhere, but I think it's difficult for Granite Staters. And there has been a long engagement between the legislature and between the judiciary, and a lot of different things have been tried. It was an experiment to move from the Superior Court to a dedicated family division. I do think we sometimes move in trends. There was an idea that it would be better to have marital masters because they would be extreme subject matter specialists. Now they're disfavored. There's only one marital master left. So we do try different things to create more confidence, to create a better experience for constituents in the family court system. I'm not sure that that has changed the level of public discomfort with bringing these very private and emotional matters into court. But we have tried different things, and I appreciate that the legislature is always looking for those opportunities to improve. If it's 100 small improvements, if it's one big one, what can improve people's experiences with the family court. But I do think there are some things that are maybe not correct. The family court is a duly constituted court with constitutional officers. It is not an administrative agency. The judges are judges. Under New Hampshire Constitution, Part 72A, the legislature can establish courts. It's noted that the Supreme Court is a constitutional court, meaning that it is mentioned and specifically created in our Constitution. Same of the Superior Court. The Circuit Court is a legislatively created court, but that doesn't make it unconstitutional. It simply means the legislature could change it by legislation without amending the Constitution. And you could do that. If you wanted to return to a period that existed in the past and have Superior Court resume this work, you could certainly do that. You don't need an amendment to the Constitution. I think you may find that there is a wave again, that there is concern that the Superior Court judges who are generalists may not be deep subject matter experts in family law, as most circuit court judges are. About 40% of their time is spent on family cases. There are 20,000 about cases brought in the family division every year. Thousands of mediations under the Office of Mediation and Arbitration, including a small amount of paid for time.
No, she gets unlimited time. Look in the beginning.
Our mediators are certified by OPLC, so they have the family certification. And it is very successful. A lot of people appreciate the opportunity to mediate. It is included in the packet they get when they do a divorce and parenting case, that they have the option to do mediation. So we certainly believe in the court system and doing the best we can for people. And we appreciate how much the legislature is looking at anything that can be better. This will represent a return to a historical period that you could study and see if you prefer the results from that period. But it is up to you if you want to change things from the Circuit Court to the Superior Court, and if you want to have 2 offices of mediation instead of 1. But I'm happy to answer your questions about how the family division works.
Yeah, thank you. Representative Raymond, we have an expert witness here. So
Yes,
lay it on.
thank you, Mr. Chairman, and thank you for taking my question. So my question is about judicial oversight or audits or, visitations and observations in courtrooms, because I'm hearing over and over again these really heartrending stories about people who felt that they weren't heard, weren't understood, didn't understand what was happening, or what's going on with their children and their families doesn't make sense to them, or judges are acting in a way that doesn't make sense. So is there currently, or can we make a system where there is Like I'm thinking about teachers. Teachers have the principal or the assistant principal comes in like 5 times a year and observes their classroom and then gives them coaching and pointers on how to do better. Is there a system like that for judges?
Great question. I think typically if there is a complaint, what you'd have is that the administrative judge of the relevant court, so if it's circuit court, it would be Judge Christo, maybe her deputy Judge Kissinger, will review that specific audio and see if there is a teachable moment, a problem. That's the boss, essentially, of the circuit court. I think one of the things that has hampered us in wanting to implement exactly what you've described, which is having very experienced retired judges, for example, sitting in with the newer judges, is that we have needed to use a lot of those judges because we have been staffing up to full staffing. The legislature's support in expanding circuit court judgeships has been so important. We are now fully staffed at 49, but a lot of those judges are new. So there is still a lot of shadowing of judges. There is still a lot of close watching and training of those judges. When we can free up some of the more experienced judges, I think that's exactly what the Chief Justice wants to do, is have our retired judges and our very experienced judges sitting in courtrooms watching the new judges and giving them direct feedback.
Follow up.
Thank you, Mr. Chairman. So I guess the question is, what does the judicial branch need from the legislature or the budget or whatever to make sure that we're having this kind of ongoing routine oversight so that when these things don't keep happening to people?
I'm not sure it's something that we need. I think we just need to start being able to pull these retired judges off of cases and be dedicating them to that. And having the full staffing of judges, which the legislature has already supported, is really the biggest piece of that. But I don't think there's a new resource or a legal enablement that we need. It's just been freeing up resources.
Representative Gregg.
Thank you, Mr. Chairman, and thank you for being here and answering questions. How serious, so we heard about like a pattern from some selected cases that they had, but how serious does the court system take complaints, or how do you handle complaints if there's about a specific judge or something like that?
There's a dedicated email, and I think I've sent it, but I'm happy to send it, which is for circuit court concerns. And that takes in everything that's related to the work of the circuit court. There are other patterns if you have complaints about other interactions in the judicial branch. And if it's about staff, it'll go through their managers. If about judges, it'll go through the judicial management chain, which is the deputy and head administrative judge of the circuit court. So if they see that someone doesn't seem to, it has had some type of issue, they maybe misapplied the law, they might arrange more training, they might do something like that. So it's typically through direct contact with the circuit court concerns, and they see complaints routinely.
Representative Love. Representative Love, sir, sit down. Representative Love. Hey, come on.
Thank you, Mr. Chair. Thanks for taking my question.
No. Go ahead.
Regarding the statement about the confidence in the family court system, I don't know about you. I've been sitting here for 2 hours, 45 minutes, listening to testimony after testimony, and nobody's spoken too glowingly about the family court system. I'll stick by my statement saying it's a complete failure.
And I think that what I was meaning to say is that concern has been around for a while. I don't think that your concern about the present state is wrong. I think that that's a running issue, that we have folks that just are not comfortable with the experience that they had in circuit court, that is a long running issue. So I'm certainly not saying that that's not the state today. I think it's been the state for a while.
I don't know how many of the sessions of the special committee you sat in on. I sat in on them all. And I heard from equally angry people of the same gender. I say that to remove the gender cross issue, that the other one just wanted to stretch the thing out by more motions. And the same room full of people, half of them would say, they won't let me bring things up. They're rushing to judgment. Okay, who's right? Would you believe that there were numbers of people who said, I want the rule changed so whatever I bring in as a piece of evidence will be admitted? No, you don't. because other people said that judge allowed my ex to come in and talk about something that I did wrong 30 years ago and it has no probative value. Which is it? Some of this is, I'd hate to be a family court judge trying to be fair when you've got equally angry people who feel like they have been dumped on by an, I can't give all the beautiful adjectives of the journalist, system, and they mutually exclude each other.
It's very hard for a family judge, but I think it's hard for the legislature. I see that our legislature was very close to the people and attempts to be very responsive, and that is why it is always changing. There is more revision of the law in the area of family law than probably any other area that affects the court system every year. And you may hear that some people are saying, I don't like that the parenting was equal, and some people are saying the parenting must be equal. And the legislature is always trying to learn from those cases and always trying to find a sweet spot. But I think it is a tremendous challenge. And what happens is that the law changes a lot in this area, and the judges are always training and always learning and always trying to hit that moving target. But in reality, people are distressed by very different and very oppositional things. They either want an automatic presumption that everything is equal, or they do not want to share parenting with the other parent or have that parenting time significantly reduced. They want to be able to introduce whatever they want, or they don't want the other side to be able to introduce certain things. It is very difficult legislatively to accommodate these concerns in a cohesive way, which is why I think we do go to Superior Court and then to Family Division and maybe back to Superior again, go to specialists and then to generalists and change the law. It's tremendously difficult to address all the different kinds of concerns that people raise.
It was my experience chairing that special committee that the judiciary really wanted to fix things. And we went, as you remember, we went for the relatively easy ones. But you know what? If you show up at a family court and you just don't know what to do, and now somebody's helping you, that may be a minor thing, but not to you it is. It's a good thing for you. And I just think of my colleague over here. She'd show up at a hearing to try to convince some of you people to do something, and you had been listening in on our sessions, and you were already in the process of doing it. You know, I think you've got the magic touch on this. Yeah, and I think the judiciary was quite open. Now, when we crank up the next round of this, we've heard testimony. I'll be picking 5 or 6 people to serve with me on this subcommittee, which will last 2 years or a year and a half. And we'll go for some of the things that we've heard today to see if we can catch them by the tail. Maybe we can't, but I don't think we're going to make it worse. I think we have some things that we are chewing on, and I hope we all will do this. And it may scare the willies out of some of you, and you will not volunteer. You'll run away very fast. But I think some of you, I think I'll have a subcommittee that can take it the next step. And I know the judiciary will be open to that.
The people who work in the judicial branch want to serve the public. They have chosen careers in public service. And to be honest, I don't know anybody wants to work in family law in the judicial branch. It is tremendously difficult. It is the area in which you face the most abuse from your litigants. It is the area in which you are sued the most. It is the area in which you are threatened and assaulted the most. In which you are accused of committing crimes, in which you are routinely reported to the police for doing your job and not violating the law. I really don't know when you could be a judge and do anything if you wanted to. You could be doing the probate cases, you could be doing the criminal cases where you just do not face this level of abuse. I really don't know. It makes me think of being a police officer. A few years ago, I thought nothing would shake a person's calling to be a police officer, and it got to be too much. And a lot of people decided they didn't want to be police officers anymore. No one would threaten to kill you if you became a firefighter. And now we have a commission studying how we get people to be police officers again. I have worried. I've seen people quit because they can't take the level of vitriol that's developed toward them. They've taken a job as a clerk because they want to do something that matches their kid's school schedule. They want to be a public servant. They did not sign up to be threatened every single day by someone. So that is something that I...
Quiet.
So it's a challenging job. It's a challenging job to do.
Yeah. Well, good. Thank you. I do have another card. It may be anticlimactic. Do you want to testify, Betty, or not? Okay, make it brief. 3 minutes.
Thank you.
Thank you. Betty Gay from Salem. I've made several points. They're not in a particular sequence, but as I've listened to really good testimony all afternoon, I thought I would just try to boil down the important points that have come up. The worst punishment is dealt with in family court of all the courts, because losing your kids has to be the worst possible punishment. Right now, we've established that in family court, we do not follow due process. And although we're getting $5 for every dollar, we're not keeping all that because we're losing judgments in court because of violating due process. We don't follow the rules of evidence, but in family court current rules, the judge can say, we are not doing an evidentiary hearing at all with no excuse. That's legal. That's not a good idea. Yes, we have mediators who work currently for family court. They are not certified by the highest standards. They can hang a shingle, but they're not the kind of certified mediator that is being proposed in this bill. We know there's a financial incentive to maintain the status quo. There's a financial incentive for the budget because of twisting the rules from Congress. Federal money is padding us, but we're not really getting it fairly. But they're not watching either, so we're getting away with it. In New Hampshire, one of the things that makes it really difficult for people, now this isn't just family court, but in New Hampshire, unlike some states, if you're can't afford an attorney, only you can defend yourself in court. Only you can represent yourself. But in some states, they allow you to get assistance from someone else who may not be an attorney, but there are at least two people behind me who had to teach themselves the law because you usually run out of money. Most people don't have the incomes of attorney to pay attorneys for very many hours. So they have to teach themselves. But most people aren't that good at teaching themselves. But some people, thank goodness, are, and they've been helping other people, but they can't go to court and represent them. Our solution is all the good people that we have in the current family court system, they can still work in a newly created court. It's just that they have to start following the rules of due process. It's only fair. As citizens of the United States, we are entitled to courts that follow the law. Thank you.
That was a very wonderful summation of one side of the argument we heard today. And you did sum it up very nicely. I'm glad you put another pink card in. So your suggestion is you might recommend through a court rule or through legislation that in family courts, a pro se litigant might have the assistance of a helper of his or her choosing.
Yes, and I understand that in some cases, in some states, that is the law. In fact, the person who said it to me, and I didn't get to check it out, swore we were the only state that doesn't allow it.
New Hampshire's always first or last, you know that. Yeah. Any questions for former Representative Gay? Seeing none, this ends it. This concludes the hearing on House Bill 652. We will exec it on the first Tuesday of March. Now, we have additional copies of the proposed amendment to House Bill 10 The only difference from what I handed you last time is it actually has all three of the amendment writers on the top where the other one didn't. And the vice chairman has gotten a pile of these because we're getting people who are saying, I don't like HB 10 because it says, or it doesn't say. And maybe, just maybe, the amendment actually has taken that into account. So if you've got people who are talking about HB 10, you may want to have one or two of these to photocopy and hand to them. It's sometimes the case you don't see the amendment until the exec session. I have decided I want it out there as wide as it can be. So take them if you want them. And we'll make some more. Thank you.